We have allowed this petition and treating his entry 18 years as per your on 1983. Giving away the period which was he was temporary. Okay. So in that terms, you can superannuate him.
Placement.
And he has made an argument of back wages that we have said since no pleading, we are not going to liberty him to file an application before you.
Placement.
Mr. Sakravati, you'll get after some time some corrections are there. Still, that's why I have not signed it. Dismissed. Keep it, huh?
May I please, Your Lordship?
Yes.
Lordship, in item number 46, we have filed an affidavit in opposition on Tuesday. The same may be called for, Your Lordship.
Item
46. Your Lordship.
what is this? Okay.
We have filed an affidavit in opposition on Tuesday, Your Lordship. The same may be brought on record today, Your Lordship.
Okay.
Like Your Lordship.
Please, Your Lordship, with the consent of the other party, I beg to mention item 27 on behalf of A.C. Sharma. He's having some personal difficulties, Lordship.
20.
27.
You are for
On behalf of A.C. Sharma.
petitioner. Okay. On the prayer of the learned counsel for the petitioner, matter stands adjourned and be listed after vacation.
Large Lordship.
Make your motion. This matter came to your lordship's idea, madam. Your lordship kindly see your lordship's order.
What happened thereafter?
Thereafter, madam, they have allotted one private person. So we had to go with and we have annexed that private person.
Yes, Mr.
Lordship, I have to take instruction, Lordship.
All along, my lords. This
Because you did not pass any interim order because
Okay. Let me immediately after.
tomorrow,
Lordship,
tomorrow we are passing a stay order. Forget about who is the person.
tomorrow.
Tomorrow you have your instruction.
Lordship.
Because you have specific statement that no NIT was
Yes,
issued,
Lordship.
so therefore no urgency.
Lordship.
Now they have allotted in the what manner?
Who was idea also, my lord.
Ah.
Last month, he was allowed to lift 2 hours, 2 hours secretary is fine. That is interesting.
2 hours secretary.
Secretary means they are the GPPS, madam.
Ah.
Gaon Panchayat Somavesh Samiti. We had to bring it from that my lord, from go down. Thereafter, he used to lift this and distribute this into the.
Lordship, tomorrow.
Tomorrow you have your instruction
Lordship.
and corrective measures if any.
Lordship.
We do not appreciate this kind of things. Yes.
Wait, please, your lordship.
Yes.
My lord,
Where is pollution control board?
My lord, I have served the copy, my lord.
Okay, Lordship, I think he is, some person he will not come today, informed. Let it be tomorrow.
Lord,
Hard. Tomorrow we'll see.
Tomorrow, he,
Tomorrow we'll see. On the non-APS for the pollution control standing council for that, then pollution control board. Accordingly, matter stands adjourned. Though name of the standing council PCB, though name of the standing council PCB soon. Tomorrow. Yes.
tomorrow, my lord. Wait, please, your lordship.
Yes. Where is the last deposit?
I tried to, I visited to the office numerous times. They have said that they are not going to accept it as of now.
No,
It's a
no.
problem.
What before that? What is the last?
Last date it was in the 2023. The 30th of June 2023 is the term tax was paid till that day. But after that, I visited to the office,
Hard.
but they are not accepting.
Where is your statement?
I have made a statement, specific statement I made it.
Huh? Where have you stated a specific statement?
Yes, I have made a specific statement with them, madam.
This is item 54. Where is PNRD? Hard, Mr. Swench. None appears for the PNRD department. The case of the petitioner is that petitioner is allotted a VETI, VHE, TEI in Udali Weekly Bazaar under Udali Anshalik Panchayat, measuring 12 into 30 square feet. Full stop. It is the case of the petitioner that the respondent Anshalik Panchayat is not accepting. Respondent Anshalik Panchayat is not accepting the rent,
Not, it's a tax,
uh,
tax and additional, annual tax and additional tax.
not accepting the annual tax and an additional tax against the said VT, and at the same time, it is the petitioner has been asked to vacate the VT in question, isn't it? Ask the VT question. A specific statement in this regard has been made at paragraph.
My Lordship, my lord.
These are the vital facts you must know. Petty number 200, huh? Huh? Petty number 200, na?
200.
Paragraph.
The fifth, starting from the fifth sentence, be that as it may, the petitioner has been visiting the office of the.
Okay,
on numerous
specific,
occasions, so
In view of the aforesaid, let a notice be issued, returnable on such and such date after vacation give a date, full stop. Considering the nature of allegation and the long position of the petitioner and the statement made in paragraph 10, it is provided that till the returnable that the petitioner shall not be evicted from the VT number 200, and liberty is granted to the respondent authorities to accept the due tax.
much obliged.
Issue a notice prepayment.
Lord, you know, we have, my lord, your lordship will find
Hmm.
how the private banks are behaving with the customers.
No, that we understand,
We have
but
paid the entire amount, my lord. And the 2%, my lord, they want to say
Hmm.
foreclosure charges, my lord, they brought it down to 1%. And how they are dealing, they are asking for 2%.
no, that we understand now how, what kind of order do you expect
Yes,
today?
your lordship kindly say at page 76,
Page
what they are
7
going to do, my lord.
76.
76, the letter dated 26/9/2024.
76, just
Well,
a minute.
Annexure 12.
Hmm.
Refer to the trial mail dated so and so wherein we have requested you.
Who is this company? What is this bank? Will a writ lie?
Your lordship will find the ombudsman because we went to ombudsman
Hmm.
and they have rejected without even looking into the matter.
You have challenged the ombudsman order.
Yes,
also.
yes.
Yeah,
So therefore, my lord, the so far Article 12 is concerned, there is no problem.
okay.
These letter may be straight, my lord, for the time.
Heard, Mr. Dutta, learned senior counsel, assisted by S. Musa as Dr. Simure for the petitioner. Full stop. The fundamental challenge in this petition are are an order dated. Where is that ombudsman order?
That your lordship will find
Hmm.
at page 83, my lord.
That is 28/3/24.
Yes.
An order dated 28/3/2024, whereby the challenge made to the action of respondent number
Respondent number 3, my
HDFC Bank,
respondent 2,
respondent number
2, my
2
yes.
was negated. It is the case of the petitioner that the respondent number 3 bank has acted arbitrarily and proceeded to declare the bank account of the petitioner as NPA.
Yes.
NPA,
They are going to make it
the
within 7 days.
NPA, for the reason that though the petitioner has paid the entire loan due to the said bank, however, the petitioner is to pay a amount of
Foreclosure amount of 2%.
foreclosure amount of 2%, which amounts to rupees
That they will estimate.
2%. It is the case of the petitioner that such action is arbitrary when the bank arbitrary and illegal and in derogation of the Reserve Bank of India guidelines and full stop. However, the Ombudsman has failed to exercise its power in this regard, and having no alternative, the petitioner has approached this court. Full stop. Considered the submission advanced by the learned counsel for the petitioner. Also, peruse the material available on record. In the considered opinion of this discourse, in the considered opinion, these matters need further consideration. Full stop. Considering the fact that the petitioner has already repaid the loan, comma, the decision to repay the loan, the decision to proceed to declare the account of the petitioner NPA for non-payment of foreclosure due, comma, foreclosure charges, comma, is prima facie arbitrary in nature and in derogation of the Reserve Bank guidelines issued in this regard. Full stop. Therefore, till the returnable date, the impugn date, it is provided that the bank account of the petitioner shall not be declared as NPA till the returnable date. That will do. Steps by registered post with AD.
Lordship, we could not file our objection that day, Lordship. There was some defective. Lordship, we are filing objection today. Copy will be served, Lordship.
What is this? Allowed. File it. That
File
same.
File
Bring on record. Huh. We are filing it today.
Yes, Lord.
Okay, bring that on record. You give a slip.
File
Okay.
your-
But copy on Saturday.
Service report on response number 2, madam.
This is item number.
58.
Why this? What is this matter?
Boxo, madam. So,
Okay.
awaiting service.
While a service to respondent is
Okay,
necessary.
okay. What is the status?
While a report not received.
No report. You will give a report.
While yes, madam.
No, it is succeeded case, madam.
Okay, succeeded case.
Here was small problem.
Okay, okay.
No, through OCD.
Steps through whom? When have you taken steps? How? Tell us that first.
Actually, madam, my junior has taken this case, madam.
Oh, don't blame everything on juniors. You must be instructed.
Through registered post, madam.
You have not even taken steps. You have not taken steps.
I will take this.
The learned, scan copies of the LCR as well as steps for service of notice has not been received. Also, the learned counsel for the petitioner. See, if I would have passed this order, you people don't have even time to go through the office note. Anyway, we are here to do that, all this. The learned counsel for the petitioner prays for and is granted 2 weeks time to take appropriate steps for issuance of notice upon respondent number 2 list after vacation.
Well, scan copy.
Registry to issue a reminder for the scan copies of the records as directed by this course under its order dated 10/9/2024. None appears petitioner on call. None did represent the petitioner on earlier occasion, that is on 29/2024. Mr. D. Sekia, learned advocate general Assam, representing the respondent number 1 and 3 on the last occasion, comma, referring to the affidavit file, submitted that the state is ready and willing to compensate the petitioner for demolition of the house during the currency of an interim order. Full stop. Full stop. However, the matter was adjourned as none represented the petitioner on that date. Full stop. In the affidavit filed by the respondent number 1, where is that? The following stand was taken. From the affidavit, it is seen that the petitioner was evicted from her land on 18/11/2014 by the respondent number 3, whereby the residential house of the petitioner was also demolished. So it is the further stand that on the date of eviction and demolition, yes.
Lordship. In this case,
Now, last occasion also you were not there.
actually, I was mentioning a matter, Lordship, after that I come here. But-
Now, what is to be done?
Lordship, here in this case, the order was very specific with regard to this.
No, we understand.
Yes,
They say that we did not have knowledge or whatsoever. We have done it, we have demolished it. Now they want to say that we are ready to pay compensation. On affidavit, Advocate General has said. Now, what is your stand? That
My stand, Lordship, I've already communicated with the petitioner. Now, the fact is that they are just wanted to know how this amount will be determined, Lordship.
that is, Advocate General says, how do you propose? Tell us. It is your proposal. They will estimate, you go through it. And if estimation is not to your satisfaction,
Estimation on the part of the petitioner is little bit difficult, Lordship,
so
because
therefore we are
Yes,
saying,
yes.
let there be an estimation. That is what, that's why your presence was very much required. That's why you have adjourned on the last occasion. You were not there on that day. It's an important issue. See, now they have candidly filed an affidavit saying that yes, okay, you did not have knowledge or whatsoever, we are not going to that. But admittedly on the date, there was an interim order. And despite that, we demolished the house. Now, being in a situation, we are ready to compensate.
here in this case, two aspects of the matter, Lordship. First aspect is that, Lordship, the RCC construction was there and that was demolished.
No,
First
that
aspect.
we and that.
And the second part is that till date, Lordship, they are staying in a thatched house, Lordship. They've not been able to make the construction.
So therefore,
taking note of these two
they
aspects.
see that
Yes.
on that background, their state is coming and saying, and
Yes.
none other than Advocate General has made a statement that we want, we will compensate. But only thing is that please tell us how to determine the compensation. Tell us. Or we will say they will.
No, Lordship, a lump sum amount if can be paid on the basis of some assessment with regard to the construction and for the last 10 years.
Understand, we cannot decide that.
Yes,
We'll adjourning this matter, let them decide, bring on record
yes, Lordship.
in terms of
And
the
quantifying the amount also, Lordship.
quantifying the amount,
Yeah, exactly.
then we'll
Exactly, Lordship.
do the needful.
Yes,
This
yes,
proposal, what do you say?
He said that you would have filed an affidavit earlier, on the earlier
No,
occasion.
I obtained the instruction, that's why I'm just communicating with the court, that I have no objection with regard to the fact that the amount is being paid. So
For
this is the
several days
affidavit
time
to
have
file.
been taken. Just-
No, that we understand, but how do you propose?
No, that is what I'm saying, Lordship. This, I've already talked, yesterday also I've talked to the petitioner, Lordship. She's saying that if the certain amount is being paid, then I will, this.
So certain amount, what is the certain amount? Somebody will have to determine that
Because the amount they are
Okay,
specified.
they will pay you,
Lordship,
they will pay you 2 lakhs.
They are.
Are you happy?
No, they are expecting around 10 lakhs, Lordship.
That
Yes.
you may get more
Yes.
because it's an RCC house
Yes.
demolished. You'll have to construct it. What 10 lakhs you are saying? We want to have a verification by the PWD.
What I've been communicated by the petitioner, that I'm saying, because she said that I don't have any means to find out how much.
She is not in a bargaining position. She is helpless. Otherwise, we could have dismissed this petition for non-appearance. You advise her. Let there be an valuation. Steel structures are there. It's an RCC building. Maybe not fully constructed, but ground floor is
Structure was there.
constructed.
I have annexed all the.
And that's
Yes.
still lying there.
Yes.
Then who will determine the valuation? PWD. Okay. And give a report thereafter. Okay, now taken the following stand. কি করলো করেছিল? So demolition. The land of the petitioner was included in the Guahatar Watar Bodies within bracket Prevention and Conservation Act 2018. However, such land is required to be acquired, and at that point of time, the Revenue and Disaster Management Department, Government of Assam, expressed their views to the effect that to the following effect, quote unquote, paragraph 46. In that background, a specific stand has been taken by the respondent number 1 that since the residential house of the petitioner was demolished during the eviction process carried out on 18/11/2014, in spite of the order dated 4/6/2014 passed by this court in WPC 2767/2014, the state government is ready and willing to adequately compensate the petitioner for the loss sustained by her due to demolition of her residential house. A specific stand has been taken by the respondent number 1 that the respondent number 1 would like to reasonably quantify the compensation amount, or to direct the authority competent to do so, find out the valuation of the demolished house of the petitioner. In view of the aforesaid stand taken by the respondent number 1, and as proposed by the learned counsel for the petitioner, let the PWD which division?
PW, actually, this is a contempt matter, Lordship. PWD is not a court.
No, Mr.
Lordship.
Why are you saying party?
PWD.
Oh, don't say party in contempt. It's between us.
PWD.
Who will do, Mr. Okay, in the aforesaid backdrop, this court has requested, Mr. This court is of the opinion that the competent or that what do you call it? Regional executive engineer is of a region.
Of the district.
Huh?
Subdivision. Subdivision.
Executive engineer is of the district or district, na?
Of the district.
Full stop. The executive engineer, Kamrup Metro District, shall make an assessment as per extant norms and submit a report in this court as regards their valuation of the demolished RCC building. Full stop. At this stage, this court has requested Mr. B. Gogoi, learned standing counsel for the PWD, to intimate the decision of this, intimate the order, forward a copy of this order and to pass today, and to intimate the concerned executive engineer to do the needful in this regard. Full stop. A copy of the order be furnished to Mr. B. Gogoi, learned standing counsel for the PWDs, as well and on all the learned counsels representing the parties. Full stop. parties, the petitioner may also remain present while the assessment is made. Full stop. After the valuation slash assessment of damage of assessment is made, a report be furnished before this court. Full stop. Registry to list this matter reflecting the name of Mr. B. Gogoi in the cause list as standing counsel PWD. List this matter on November 5th.
Should report maybe in the form of affidavit or this because I.
Let us, it
It
is
is
a
a case
report
report or-
by the court's direction. So we'll see.
Doctor will say the concern executive engineer.
Concern executive,
Okay, yeah.
concern executive engineer.
Probably.
Not
ऊपर नाने पेश की ना लगे ना
Step has been taken, my
Hmm?
step has been taken, my lord, order of December.
Steps taken.
Yes, ma'am. 24/7, 2024.
May I please your lordship, I am appearing for newly implemented different respondent number 10 and 11.
Hmm.
10 and 11.
Yes, what do you do? What? So service is complete.
No. 7, 8 probably not need after receiving, my lord. 6 is received, my lord. 7 and 8 not found, guys.
Present address of 7 and 8. You are representing whom?
My lord, I am representing 10 and 11, substitute newly
Okay,
implemented.
okay.
And
Now
we have
take
not
fresh
been-
steps. In view of Lawajima Court's order dated 27/9/2024, learned counsel for the petitioner prays for 2 weeks' time to obtain the proper address of respondent number 7 and 8 and to take required steps upon the aforesaid respondents. Prayer is allowed?
My lord, our name is not reflected.
Okay, list this
And
full stop. List accordingly. While listing the case registry to reflect the name of the counsel, name of the
deed in the
learned counsel for the respondent number
10 and 11.
10 and 11.
And my lord, the copy may be provided to us.
If
They have
copy-
not served the copy till date. Deeply obliged.
List of the facts. List of the 4 weeks.
In this case, my lord, we have taken the service upon respondent number 5, lordship.
How many respondents?
Lordship, total 5 respondents.
Hmm?
Total 5 respondents. Upon 5, my lord, we have taken the service on 3/9/2024. We have already filed affidavit, lordship, additional affidavit on 25/9/2024, lordship. The service is completed.
Uh, the petitioner has taken steps to dusty upon respondent number 5 and also filed an affidavit. Full stop. At paragraph 2 of the affidavit, a specific statement has been made that the notice was duly received by the respondent number 2. Peruse the pleadings as well as notice and signature of the respondent number 5 and seal accordingly. The service upon respondent number 5 is accepted. List this matter after puja vacation in the admission code. Interim order pass earlier shall continue till the next date of listing. Yes. Yes. Where is the order?
The annexure 1, my lord, page number 7. Page number 7, annexure 1.
Order of 2013. Contempt is 2023.
My lord, thereafter communication were taken place in the annexure 2, my lord, can you put next page?
Communication, forget about that. Where is the communication? Annexure 2.
Like given by the executive engineer, Barpeta, Water Resource Division, Barpeta.
When?
1/12/22, my lord.
Then what is in between? Contempt is within 1 year.
Yes, my lord.
Then
Is that communication was going on?
communication is going on from communication will not save your.
Department assured us to make the payment time and again. We have
On the prayer of vacation saved you. On the prayer of MSRM R Deka Learned Council for the respondent number
All the.
or respondents, matter stands adjourned and be listed after vacation. In the meantime, the respondent council may file their affidavit.
Well, in this case, 39, 14, no?
No, 39.
Contempt.
Oh.
My name is wrongly shown in this pre-contempt cases, Lordship.
Okay,
Also
name of Mr. Sisti be deleted from the shall not be reflected in the cause list
Yes.
as his name is wrongly
Yes,
reflected.
Lordship.
In item number
39, 40, 41, Lordship.
39, 40, 41. Yes.
Avla
Yes. What is the next case?
Same here, Lord.
Same all these 2014.
Yes.
same petition.
Okay. Or you want to argue this case?
After vacation.
After vacation. Better.
Apply the. Please, Lord.
My lord, the chief engineer has submitted proposal to the government, my lord. We are waiting for the approval regarding land compensation. My lord.
Okay.
After 4 weeks, my lord.
Mr. Gogoi, Learned Counsel for the respondent submits that the proposal for payment of land acquisition compensation and necessary amount of money has been sent by the chief engineer
My lord.
of
Chief engineer, my lord, PWD roads.
PWD roads,
On-
and the process may require some time.
My lord.
Accordingly, he prays for an adjournment. Prayer stands allowed. Please this matter. Give a date in the month, second week of November,
Lordship. Oblige.
12th of November.
Ma'am, to you, Lordship.
Yes.
Lordship, may I pray 2 days time to take step upon respondent number 4, 5, and 6, Lordship, private respondent.
The Learned Counsel for the petitioner is granted 5 days time to take steps for issuance of notice upon respondent number 4, 5, and 6. In terms of this court's earlier order dated 8/9/2023. Yes,
So this order has not been complied as yet, Lord.
yes, Mr. Bo, who is for the respondents? What is the order?
But can you find at page 15, my lord?
Page
15.
15,
Yes.
operative portion,
Operative portion, my lord. That's page 18. Para 6.
non-payment.
Regarding, Lord, there is a violation of the provisions of the GMC Act while
Hmm.
construction, Lord.
Hmm.
Your Lordship has directed them, Lord, we have filed this writ petition directing the GMC to carry out assessment of this. And therefore, this direction was passed, Lord.
Now you are having your house, no difficulty.
No, it's not a house, Lord, it's a residential apartment.
Okay.
There the builder has done, Lord, he has wiped out the parking places, Lord, children park. And then, Lord, illegal construction has been given, has been made,
Hmm.
and it has been allotted to some commercial rooms, Lord.
It's where is Mr. Bora? Yes,
He's on legs.
we understand, but we are sitting here.
It may be.
He might be in legs.
Time.
Wait for something.
Ma'am, please.
Yes.
Lajima court order 9924.
In terms of the Lajima course order dated 9/9/2024, the matter is ready as regards service. Full stop. Accordingly, list this matter in the admission column after vacation.
Oblige.
In the meantime,
Oblige.
least after 6 weeks.
Lordship may kindly pass over for timing, Your Lordship. And for respondent number 5, Your Lordship, my senior is on legs.
Who filed this affidavit?
Affidavit in opposition, Your Lordship, respondent number 5, Your Lordship.
We'll take after vacation.
Lordship, there is a stay order that for that reason.
Who is your senior?
PK Deka, Your Lordship, he's on legs in.
No, understand, your senior is PK Reka. You have filed an objects affidavit in opposition today,
On Tuesday, Your Lordship.
Tuesday. That is before us today. We'll hear it after vacation. An affidavit, non-appears, but an affidavit in opposition has been filed by the respondent number 5. So service is complete.
Other respondents, I don't know, Your Lordship.
Who are the other respondents? Okay, we'll wait for some time. Yes. Yes.
Lordship order has sensed the whole scenario, Lordship. Now the work order is given, and the only paragraph 3, Lordship, to take care, because they said that it is 1 year from the date of agreement, Lordship. That is what the paragraph 3 of the letter. You have already given bank guarantee and everything, we'll accept whatever they want. Only that it is 1 year from the date of signing of the agreement.
Good. This is for your interest.
Yes,
Okay,
Lordship, that
okay.
is what.
Ah.
That is what Lordship have to say, because they are worried, Lordship, because already 10 months has gone. So.
No issue. Full stop. No, sorry. It is submitted by Mr. Sharma, learned senior counsel, that pursuant to this court's order dated 10/9/2024, the petitioner attended the office of the principal cum chief superintendent Nagaon, and subsequently an order has been issued on 20/09/2024 or by awarding the contract in question in favor of the petitioner for 10 months with effect from 29/11/2023.
Not 10 months, Lordship, it is 10 months has left. So they
Okay,
want
no,
to continue for 12 months
Okay, that's
on the date of.
what I have written last. For a period of 1 year from the date of execution of the contract. In view of the aforesaid, nothing survives in this petition to be executed. Accordingly, matter stands closed. Matter stands closed. IA as well as read petition both.
Lordship.
In view of the order passed in IA, nothing survives. Just write down the name of the standing counsel. That's all.
I'm grateful.
Department.
Health Bora for Health Department.
Lordship, in this case, we have already gone for paper publication, only the affidavit needs to be filed sometime maybe. Lordship.
Okay, Mr. Das, learned counsel for the petitioner, submits that the petitioner has taken steps in terms of this court's order dated 11/9/24, 11/9/2024. However, the affidavit has not been filed in proof of such service. Accordingly, he prays for an adjournment. Prayer stands allowed. List this matter after vacation. In the meantime, affidavit be filed.
Interim order to continue.
What was the interim order?
What is the
Please
interim
give a
order?
date. Huh?
There is an interim order not to take any coercive action.
Okay, give a date then. Mr. Nath is there. Give a date.
Statement,
Mr. Nath for state. Give a date.
for
13th of November 2024. Till then, interim order parcel is not completed.
Right.
What is this?
I'm given time to file affidavit, Lordship.
Okay.
May I please, Lordship? The respondent number one,
Hmm.
no, service has not been completed.
Hmm. Who is respondent number one?
One is
Huh?
insurance ombudsman, office of the insurance ombudsman. As per the office note dated 110,
No, have you taken steps? Huh?
it is yet pending on us.
Huh?
That is yet pending on us.
You have taken?
No, Your Lordship.
No.
One we have not taken.
When will you take?
We'll take it.
Okay, learned counsel for the petitioner submits that he will take steps for issuance of notice upon respondent number one in terms of the Lawajima court's order dated 1/10/2023 within a period of 5 days. Full stop. Mr. Swenso, learned the counsel for the Goswami, huh? Learned counsel for respondent number 2 to 5. Press for and is granted 3 weeks time to file affidavit in opposition. You also want to file? No. That's 6. List after 4 weeks. Orders. Why this matter is listed today by order? Huh? None appears for the petitioner on call.
I am policy aims.
Await service report in respect of respondent number 3. Mr. Gogoi is present for
1 and 2 aims.
respondent number 1 and 2. List after 4 weeks. Yes. Affidavit, I have call, I'll go through it, pass an order.
Lordship earlier, Lordship rejected the application. And Lordship, their ground is that the inclination of delay.
This is, that is the thing, okay.
But from here, her position, Lordship, it was recovered. And Lordship has observed in Lordship's order that materials were recovered from her. And Lordship granted 6 month time to the authority. Now we have filed application for splitting of the trial. And Lordship,
Yeah, and it is it on material on record, that affidavit?
Yes.
Okay, we have call, will go through. We have called the affidavit. You file it, you have.
we already filed Lordship and we have issued that court party has issued slip also.
44, 46. For admission, item number 1.
How busy are you, Mr. Mahajan, today? Can you take it after some time?
Yes, yes. As your lordship pleases.
No,
I'll be on your.
just I want to hear some, will not conclude it today.
Yes, yes, madam.
Just I will phrase the things.
My lord.
So let us,
Kindly accommodate me, Lordship, then.
no, just we'll hear Mr. Mahajan on preliminary, a bird's eye view on the principle of law.
Lordship.
Okay, our idea on the last occasion was Mr. Bhorali also sought some time. So therefore, we'll just hear Mahajan on a bird's eye view, what is the settled proposition of law in this regard, and the power of judicial review, when to be exercised, when not. Then we'll come to the facts. The principle of law is same. Then we'll fix this matter immediately after vacation, and then we'll take a call. In the meantime, I'll also do some homework. This was the idea. Okay, so
Anytime, madam. I am on the.
you be there. Will
Yes, madam. Yes, madam.
let us complete this list.
Yes, my lord. Yes.
No, don't worry. In fact, Mr. Bhorali also requested not to list. Despite that we have listed, he will be out of station. So as a whole, we are not going any serious matters before today, before vacation. That is for sure. Not going to deliver a judgment of 10, 12 pages. 1 page, 2 page, up to 4, 5 pages, fine. Not beyond that. Yes. Along with this, huh?
One lordship.
I understand, you have expressed.
Do something is there, lordship. Two years because lordship, the honorable Tata court has fixed the matter, lordship, for that part, lordship, regarding
We will see
acceptance
that.
part, lordship.
That-
Lordship, lordship.
Because in two, Mr. Bharali was there, he said that he will
One
not be
lordship-
available, then also you have fixed this matter.
One lordship, there is no objection. One lordship, something.
No, objection is, I cannot pass a judgment, no objection, therefore
Lordship,
allowed. I will have to write a judgment.
Lordship.
And for that principle of law, will
Lordship.
today will note it down. If time permits, if not, then after vacation.
Lordship, obligation, obligation.
Yes, next.
Can we pass over? Can we pass over for the timing? Actually, SS Roy was handling this case. Like, after some time.
Okay. Timing. Huh? Mata? Where is
Number 5, just.
no scope then today? See, record is there?
Record is there, we have to just give the clarification.
Huh.
And wants to make one submission regarding some development.
Then today not possible.
He is coming, just coming, just.
Let me clarify, then in the meantime, he will arrive. I'll take 10-15 minutes.
Okay, let us, are you busy in some undercourts?
Lot of cases are there, but this is top priority.
Okay. Now we start right now or let him come?
Just, he's, I think just two
It
items.
will be better if he is there.
He is there.
I do not want to do it in his absence.
Okay.
Just time.
We'll apply our mind in the vacation.
Lordship, we are waiting, Lordship, let him come.
Okay, okay, let us finish the
Yes.
short matters.
Lordship.
No, we'll finish the other matters, then we'll come back to you.
Lordship.
Malat may come up after
Vacation.
vacation.
Affidavit is not happy.
Yes, that I have been interested. That is why I will go through all this.
Yes, you go through it.
I'll
I think,
if necessary, I'll file an affidavit also.
yes.
If necessary.
You are representing the circle officer,
My state respondents.
state respondents.
My lord,
You go through the circle officer's
Yes,
affidavit
it-
and we have
that
raised
will
certain
go-
issues.
Yes.
See, sometimes
that is why, my lord.
subject to what you argue, this is not the way a circle officer
my
should act.
Certain.
And he needs a counseling, subject to, we may reverse our views after hearing you. But this is not the way to act.
That is why, my lord, if necessary, on behalf of the deputy commissioner, district commissioner, my lord, I'll, if necessary, I'll file it.
Yes, yes.
First week of
It is
November,
submitted by Mr. Goswami that he has specially been, additional senior government advocate, that he has specially been entrusted to argue this case on behalf of the deputy commissioner as state respondents as important issues has been flagged by this court under its order dated 3/9/2024. Accordingly, he prays for an adjournment. Prayer is allowed. List this matter on 4th
of
November.
Oblike.
You go through it.
Yes.
We are open. No
Yes.
problem on that.
My lord, only thing, my prayer is to reflect my name, my lord.
Okay, registry to reflect name of Mr. Goswami, B. Goswami, learned additional advocate general in the cost. Yes, who will enlighten us on this point? Who are the respondents?
Mrs. Boro is absent.
Huh?
Mrs. Boro is.
He is not
Today
available.
we are not going to decide, but this is an important issue.
Lordship.
How award is to be executed under land acquisition under the
Earlier.
no, not earlier act.
NH Act.
NH Act. And as a stand has been taken regarding Solatium. Okay, on the prayer of the learned council for the on behalf of S. Borua.
S. Bora, R. Bora,
R. Bora, which R. Bora?
NH Act.
Okay. Matter stands adjourned and be listed on 4th of November. You also just think over it, how to
Yes.
proceed. Yes.
Lordship, in item number 4. records are just received, Lordship. Let it be after. I have to go through the record. Lordship.
Okay, it is
Item number
submitted by Mr. S.S. Roy that he has received the record. However, he would like to go through the same
Lordship.
and accordingly press for an adjournment. Okay,
After the vacation.
okay, Priya, release this matter on. Again, fourth, this matter be on
Lordship,
fourth,
on 6th, Lordship.
sixth.
I'll have this.
Yes, anything, sir?
May it please your lordship,
Ah,
in this matters, I am appearing on behalf of B. Gogoi, my
Ah.
lord. May I prefer listing matter immediately after the.
anything survives, sir? Please tell us.
We do not have instructions from the client, but.
See,
but the matter may be
simple
listed
thing,
after-
there was a, why should all these matters be kept pending? Simple thing. They were entitled for, rightly, wrongly, whatsoever, they were given capital subsidies.
No.
Okay. Now capital subsidy is disbursing authority is the net fee. Who is representing net fee here? You are referring to it. So net fee is the authority who will disburse this loan. Now income tax department says that they are liable to pay taxes and all. So therefore, don't pay them the capital subsidy. Now court passes an interim order saying that you cannot do this prima facie, therefore that decision was stayed subject to recovery by other means provided under statute. Now in the meantime, subsidy has been paid, that has been taken away. We do not know whether you have taken any action against them. There is no stay for them. So we'll close this in terms of the interim order.
My
Matter
lord, we are yet to file an affidavit from on behalf of Finance and Taxation Department, my lord.
What
But in fact-
affidavit do you require? Show us your power that you can ask somebody not to do this. You proceed. There was a liberty given to you to proceed against them.
My lord.
Did you proceed? Nothing will dispose of in terms of the interim order. That's all. It has become infructuous. Is not it?
In fact, Lordship, subsidy is not yet approved also.
That is a different issue. That is not the subject matter here.
My lord, let my learned senior appear in this matter then. Timing, my lord.
What is your instruction?
My lord, my instruction is I have been instructed to pray for the matter to be listed after vacation, my lord, because yesterday
Reason?
we were communicated.
Huh?
In the meantime, we will file our application, my
Yesterday we
lord.
were communicated.
Why unnecessary? These are wastage of time. Where is Mr. Gogoi is appearing?
My lord.
Okay, we'll adjourn it, but we'll ask Gogoi to have the specific instruction. Call Mr. Gogoi.
My lord.
Okay.
19.
PWD are the main party.
Huh?
PWD.
None appears for the petitioner on call. List this matter after vacation. Interim order was earlier shall continue till then. I think money has been paid.
I will say,
Mm.
that's why they are not appearing.
Money has been paid because a specific amount was earmarked. Court passes an order that money will go back. Court says don't return it back. So in the meantime, that might have been paid.
Maybe so.
So we'll see that. Yes, next.
20.
List this matter before any other bench without me.
21.
None appears for the petitioner on call. None did represent the petitioner when the matter was called on 17/10/2023 and 19/4/2024. In view of the aforesaid matter stands dismissed for non-prosecution. Mr. Bora, that there is a contempt. What?
Well, lordship, that the process is that hearing had to be done. The process is on to call them and hearing, then after pass the order.
Okay.
Because there is some parking
I
error.
don't
which are
understand now.
some-
What is the stage? Tell us that.
stage
You have
that-
not filed affidavit.
No, we have not filed it because hearing had to be done.
Ah.
Lordship will proceed after vacation. In the meantime, the process is on to call them, hearing to be done, and
Okay.
Yes.
Okay, we could understand. Let Mr.
Dubey is there.
Dubey is there. Okay, we have pass it time. Next case.
52.
Wait, please. Your Lordship.
Yes, service is complete. Affidavit file.
No.
See, the fight at the time of date also. Yes, state. So you have allotted to whom?
They are fighting between two parties. One is the covered son, and third is Malcolm.
So let them jointly do 50-50.
They are
Uh,
allowing.
Okay, file an affidavit, take that stand.
Yeah.
We'll pass it. The matter stands adjourned on the prayer of the learned state council to enable them to file affidavit. List after, you are enjoying now? No, they are enjoying. Okay, list after.
23.
None appears for the petitioner on call. The case of the petitioner is that land of the petitioner has been taken by the national highways without due process of law. On the other hand, the NHI has taken a stand that the petitioner's house was constructed over right of way, and such right of way was declared long back. Therefore, the petitioner is not entitled for any compensation. Full stop. However, no reply affidavit has been filed. None appears for the petitioner on call.
Yeah.
However, in the interest of justice, matter stands adjourned and be listed after
Your
vacation.
Lordship, I appear for respondent numbers 1 and 8.
Bora for respondent number
1 and 8.
1 and 8, and you?
Lordship, I'm appearing for respondent number 3 and 5.
3 and 5. Okay.
Arrest wrong.
Right, Sedun. Acho, yes.
24. Kindly pass over the matter for the.
No time being.
Lordship, give me some time.
Huh?
To call my senior.
No, I understand. Yes, what you say? There is a stay already, isn't it? Huh?
In fact, Lordship, I have filed my affidavit today, Your Lordship.
Okay. It is submitted by any stay order? There is a stay order.
There is a stay order.
It is submitted. No stay order. It is submitted by Mr. Bodole, learned, not you are Mr. Bodole.
Bodole,
Bodole, G. Bodole, Learned Standing Council Cooperation Department, that an affidavit has been filed today. Same is not on record. List this matter after vacation. In the meantime, the petitioner may file response to such affidavit.
Wait, please, your Lordship.
Yes, from your college.
My Lordship,
I filed my affidavit today, Lordship.
Okay, what is your stand?
Lordship, some construction works were left uncompleted, Lordship. And that is why, Lordship, there was a resolution by the governing body not to
Okay.
release it until
It is submitted by the Learned Council representing respondent number 4, that an affidavit has been filed today. Same is not on record, same order, huh? After 4x.
Right, Lordship.
Yes.
Lordship, in this matter, we need some time to file a.
Okay. Mr. Sharma, C. Sharma, Learned Standing Council for
Water
Resource Department, submits that he may be granted further 2 weeks time to obtain complete his instruction in terms of this court's order dated 15/3/2024. Prayer is allowed, list after vacation.
Bless you.
28.
Yes, where is Election Commission?
My lord, this matter has become infectious.
It is why?
The reference has been
Made. Okay. The Learned Counsel for the petitioner submits that a reference has already been made against the petitioner and registered as FT within bracket 3 GLP/1934/2024. And in view of the aforesaid reference, this matter has become infructuous. Accordingly, the matter stands closed, being infructuous.
published.
Receive instruction, one week after vacation.
What is your instruction?
Lordship, payment is under process, Lordship. Because of non-availability of fund, we could not pay
Okay,
that.
it is submitted by MS Bora, Learned Standing Council, Learned Standing Council
Yes, sir.
for Agricultural Department. Submits that she has received instruction that money claimed by the petitioner could not be paid for paucity of fund.
Lordship.
Full stop. However, she would like to file an affidavit in this regard. Prayer is allowed. List this matter after vacation.
Hello, please.
Yes, where is Mr. Sharma? Granted remission?
No.
Wait for some time. Are we going for final disposal?
I'm at your lordship's.
If we
Lordship
are
may
going-
hear their style, I'll reply tomorrow, lordship.
Oh, no, no, no. We'll decide.
Because I have 2-3 other matters also.
In that case, madam, subject to what my learned friend says, let it be immediately on reopening.
21st.
21st.
I will just.
See, if you are going for final disposal, then we'll pay, list, take up this matter after list is over.
Let it be on 21st, lordship. in that
21st,
case.
as agreed to by the Learned Council for the parties, list this matter on 21st of October 2024.
Lordship.
Interim order, parcel shall
Lordship,
continue.
For final
till-
disposal.
That is already there.
Yes.
Standing council of the GST says that same matter is pending before the apex court, lordship. Could you say that? So,
Affidavit, will not, affidavit file.
yes, lordship, they are fine.
Any stand taken in that affidavit?
No, lordship. But today morning, they have received the instruction, they said.
On the prayer of the Learned Council for the parties, list this matter on, give a date in the month of November. 18th of November, interim order parcel shall continue till then.
I'm also paying for time being, Lordship.
Okay. On the prayer of the Learned Council for the petitioner, matter stands adjourned and be listed after the case. Time being,
After some time, Lordship, like.
yes, affidavit file that limited.
My lord, Mr. B. Gogoi appears for this.
Affidavit file
I think, Lordship, they have not filed.
as limited, issue was limited. Okay, after some time.
After some time, my lord.
P6 of supplementary list.
None appears for the petitioner on call. Please this matter after petition.
Okay.
57. Yes, where is Mr. Gopur?
He's on election court number 4. Can it be taken after some time?
Like, you call this other matters, admission and all, leftover. We'll just finish the leftover matters. Happy that people are ready to do hearing matters on 3rd.
P 46 I'm at 46. 46.
After some time, your lordship. I have
No, after some time now.
I have already informed Pranjal Sharma, your lordship.
Where is he?
He's coming, your lordship.
Well, after vacation immediately. What will he say? You have not received the remission. He will seek another date.
They have taken possession, Your Lordship. We are not in possession. Therefore, Your Lordship, after some time, I have already.
You want remission. They have taken a decision to give you remission. Isn't it? Now, only question is that order of remission is to be issued. How it is related to possession?
Because they have cancelled my settlement, Your Lordship. On the
Huh?
ground, they have cancelled my settlement, Your Lordship.
Uh-huh.
On the ground of for not making.
Yes, next.
After
That is the case. Huh?
in the meantime, my lord, only inspection will be carried out in few days, my lord. Thereafter, the hearing will have to be done.
Okay. Mr. S. Bora, Learned Counsel submits that the process for implementation of the order shall require inspection of the building in question as well as hearing of the owner, hearing of the affected parties
Including
and hearing. Full stop. And it will take some time. Therefore, matter may be adjourned and be listed after vacation. Prayer is allowed. List this matter on
Second week of
November.
Second week of November, third week.
You do it in the
What's in
meantime.
the process?
Yes.
Problem.
Okay, 6.
Yes.
But in this matter, I am representing respondent 5. We have filed affidavit in this
You have
case,
seen
my lord.
that.
And my lord, in this case, what happened, my lord? The disputed question of fact also
Now,
involved in
please
this.
tell us, are you going for final disposal today?
Only one point, my lord.
I have to reply also, madam.
No. I am asking him, take your seat.
Ah.
Are you going for final disposal? No.
Lord,
Because you have filed an affidavit today, you have brought on record by mention.
and
Okay?
I'm concerned about the interim order
No,
continuation.
understand. You have not filed any IA. Had you, even if you have filed an IA, you would have taken time. So let us not waste time.
Yes.
As simple as that.
Order challenge is appealable under
We'll
1113, my
see
lord.
that. We'll see that.
My lord, in very opening date, my lord.
Okay. An affidavit in state has not taken any stand. Very vital stand. A serious allegation is against you. You have to held meeting in private residences. So all considering all that, we have passed an interim order. And if you want that to argue on interim, we are make it absolute for the
My lord, this is actually the, my lord. The
so
submission-
therefore, if you are arguing, I have expressed my view.
The
We'll
tech-
continue with the interim order with a detailed reason order for it, so that you can prefer an appeal tomorrow.
My lord, the plea taken by the respondent,
Please listen. If you are ready to there for that,
then
we are
tomorrow,
proceeding.
my lord, tomorrow for interim, my lord.
Until and unless the state is saying anything, we are not listening to you for the time being.
But the plea they have taken, it is not in the
Please.
pleadings, my lord.
Sometimes we pass order to protect justice. We have also seen that certain things are not on record. Despite that, we have passed an interim order. An affidavit has been filed by the respondent number
5, my lord.
5. The learned counsel for the petitioner prays for and is granted 2 weeks time to respond to such affidavit. List this matter on
Date 6, my lord. Thank you.
immediately after reopening, maybe 21, 22nd, 24th.
23rd, my lord. Any date. Deeply obliged.
Oblige.
Interim order pass alias shall continue till there.
Oblige.
34.
List this matter on the as agreed to with the learned counsel for the parties. This matter after vacation and on 21st.
Oblige. 35.
That you have bail hearing. Huh? That we have taken already. Okay. Where will Ahmed is not okay? We'll pass this order. Keep it. In the chamber. Okay. Call the. Now what to do? Mr. Chaudhary is not here. Then Mr. Mahajan we have kept Mahajan waiting for hearing a matter. But it will take some time.
I'd like to clarify, Lordship, because there were some queries from the Honorable Court also as expressed earlier.
See, I have just seen the pleadings. I have already recorded whatever you have
What I am
argued.
going to place basically the relevant provisions of the law.
That is what I want
Yes.
from the both the side. Factual aspect from both sides, it's clear.
Clear.
Don't take it to be an decision. I would have liked to make this opinion, express the preliminary opinion in presence of Mr. Chaudhary, that this is the man who has initiated all the things except the order of this Disaster Management Authority, first order. That is an order which is actually in the public interest. All subsequent review and all at the behest of this man, including a breach of 4.5.
Absolutely, Doctor.
And that twisting has been continued by them. We'll definitely look into the matter in terms of the municipal provision. If the legislature thinks that in this area there can be a building of 100 feet, we don't have any problem because this is
Yes.
the act of the legislation.
Absolutely.
We'll look the matter in that perspective.
Absolutely, Lordship. We also
But-
do it from that perspective.
Yes, that perspective.
Who
If
is
it
who-
is
who-
true,
there is
we
no
are
concern.
not concerned all.
Yes.
But from initial stage, this is a thing which has been by different means this has been done. Otherwise, this situation would not have reached today.
No, it has arisen because the two conditions in the MOU and the deed of agreement.
See, Mr. Advocate General, forget about all this.
Yes.
Can a bridge be constructed like that manner?
No, it was
I'm telling about that history.
2013.
2013. Okay. That bridge permission was granted.
Granted.
That challenge was not end into a
No, it was
logical,
challenged
not logical conclusion.
Lordship.
Because it says that these are factual determinations will not go, it was closed in that way. Don't take, why I'm again
Absolutely.
saying that don't take it to be in my opinion, I will go by the law. That's
Absolutely.
all. That's
This
all.
is what we want, Lordship.
That's all.
And we also have done it. And when the bridge was constructed or the permission was granted, I have gone some through the records. The local people were very delighted that the bridge is being constructed. That will give a different.
No, that is
that
having an
opinion is
advantage.
also there.
No, that having an advantage.
Advantage.
Suppose tomorrow another bridge is being constructed by private parties. Will the state allow? At that point of time, I'm saying.
Now, if Lordship looks at near Kumar,
we may not. We may this may be a too late in a day to go back
to turn the clock back.
To turn the clock back. But the way this has been done,
and who initiated it?
That is what I'm saying. We'll see. So therefore, I wanted the provision of law. That's
Yes,
all.
provision
And
of-
I'm not making it CAV. I am just keeping it immediately after vacation so that any clarification is required.
Lordship.
I can have it on that date. On that day, in fact, we may deliver the judgment as oral judgment, or we may seek some clarification on the next day. But not keeping it CAV. Once it is CAV, I cannot take opinion or any view. While going through dictating, there may be some confusion. Yes.
Absolutely no hurry.
So where is Mr. Chaudhary?
Or let the matter come up on 22nd, 21st on that day.
Not possible. It cannot come before 4th.
Oh, Lordship.
Okay, list this matter for further hearing on 4th.
Lordship.
But give me the record so that I can go
Or
to it.
Lordship, I can place the law so that it will, if any.
That will be
Yes.
required. Just give me the provisions which
Provision.
are the important.
Yes.
As an advocate general, forget about
Yes,
that.
Lordship, that is why we have done it in that manner only.
ah.
And we'll give one judgment also where Lordship was also a counsel. So this Lordship will kindly take the 2000, the relevant portions we have stated and we have quoted also
Okay,
later
this
on.
will help me.
2006 bylaws, the relevant
And
portion.
Mr. Deka, I want the either in which compilation or I want separately that all these laws to go through. Huh? That I have asked Mr. Chaudhary also.
All the laws, Lordship.
All, not from these books and all.
Yes,
Lordship. So 2006 bylaw, the
Hmm.
relevant portion is definition of road is at 2.54.
Hmm.
Then bylaws 558.1,
Hmm.
road width with FAR,
Hmm.
bylaws 38, wider road to be considered.
Hmm.
Then 2014 bylaws,
Hmm.
dead end road, I'll give that definition also.
Hmm.
Bylaws 26, road width and FAR of 2014 bylaws,
Hmm.
24 and 29, wider road to be considered.
If I can say whole, forget about all this, who is chairman, who is, forget, if
No relevance.
if you go beyond all this, now the first question will come to go to that, whether there is any twist. If twist, then we can go for the bias or something. This is a
Yes.
preliminary opinion.
Absolutely.
So therefore, I want to first understand a fundamental argument, if we can summarize of Mr. Chaudhary, forget about for the time being, locus standi, this, that,
Lordship.
keeping aside everything, that by widening the road in front of the building cannot be considered. This is the fundamental argument, because this is a dead end road, and in case of dead end road, it should be treated to be 6.6. That this is, if that 6.6, there is no dispute raised as regard 4.5 in the road or in the Torunnagar road. There is nothing. Or the bridge is 4.5, therefore it is less. That is nothing. Their whole case is that the end point of calculation should be 4.5 and the other roads. And if you take the front road, then it should be 6.6 being a dead end. Whatsoever, even if it is 12 feet, that will be the dead end. This is the whole argument.
Yeah. That was not their original argument.
No, as per law, they are saying that.
Now, regarding 2000, next page, Lordship will see. Issue is Anil Nagar Road or Torun Nagar Road joining.
No, we are not going to facts now, right now. Just
Next page, Lordship.
Okay.
This is regarding
Okay, bylaw.
2006 bylaws. Issue Torun Nagar and Anil Nagar roads joins forming a square. Width of the street at square is taken. This, although square has not been taken, road means and includes any highway.
My Lord Justice Salami Sir Judge.
Yes, Lordship, that judgment I am giving. If tomorrow day comes that you should be calculated on the basis of square, they will be entitled for more FR. That is why this judgment. In this judgment, Lordship's name may be wrongly recorded in the surname part. In any way, that is thus for, as because law is being discussed, so I am placing that square also. Actually, we are not taking the square. So one additional floor was granted in that case, Salami Sir's judgment. So I'm just giving a passing reference regarding 2.5.
Judgment I was searching because I recall arguing this.
Then 2006 bylaws FAR is on 8 meters or more, road is 200. So the floor area 58.9 Roman 2 says floor area ratio, the coverage and the width of the access road for the various types of building is given below residential. The FAR for different widths of road access shall be road width meter FAR up to 4.4, 100, 4.5 to 7.9, 175, 8.0 and more 200. So that is regarding 2006, on the basis of which the writ petitioner got it in 2009. Pausing here for a moment, Lordship, I'll give the inspection report of that part. The records also, I am giving the photocopy now. The records also we are placing it today itself. This is the checklist when he had applied. Record to the So I'm giving the original records, Lordship, kindly. Page number, you understand? So Lordship will have sufficient homework during the vacation.
No plan, therefore I want this.
In our school days, we always are worried for the homework during the vacation.
After many years now, I'll refresh all these bylaws, GMC and GMC.
What I have done, this book contains everything.
Okay.
So I'll hand it over.
Okay.
in concise manner, all the bylaws are.
But what we are proposing is, Mr. Chaudhuri, we are just, I am saying, I have told Mr. Advocate General also. Your client is also very smart. See, what for
How does people survive if one is not smart?
yes, yes, Mr. Chaudhuri, what I am saying is, I think in the whole process till now, the best decision was the decision taken against you by the Disaster Management Authority, some officer
2013.
long back. This was the right decision taken till now in this process, in this project. But that also got review. That also got
Going
review.
by that
Oh,
logic, my lord,
yes,
now what is happening now is a disaster. Going by that logic.
maybe. Ultimately, that was
The disaster is regarding the affair, not with others. The disaster is not with the local area. The people are more than happy there.
Now, Mr. Chaudhuri, this is one way. And then everything ended in repetition. All taken note of and said that these are facts, case of facts. Let this matter be buried there. Matter is this.
My lord, my only concern or anxiety is, my lord, the road in front of Guwahati High Court, it will remain constant, my lord.
No, you forget about all those things.
If
Our
the Guwahati High Court decides to bring back the boundary wall by few feet, the road doesn't become widened, my lord. Road remains the same.
no, but in average they get
No, my
this.
lord. No, Lord. In this case, losses.
No, that we are not going to the facts
Yes,
right now. See, fundamental case, therefore I want the bylaw. Your fundamental case is that if you take whatever you take for all this road, no dispute, 4.5. Only thing is that
Just refresh my submission. The Anil Nagar bylaw.
let me complete that. The Anil Nagar road, which goes in front, abutting to the plot.
Yes.
Abutting the plot, road is also taken for measurement of the road width.
Yes.
Okay, that is 12 point something.
No, that is only
Listen, that is 12.5. According to you, whatsoever you do, that being a dead end road,
Yes.
it should be 6.6.
So, me, my lord, the bylaw.
No, that's why this is your argument. If it is 6.6, if we accept all other 8.5 and all, then also you will not get that is the illegality committed by the GMD.
And secondly, my lord, Torun Nagar bylaw, it stops in the bridge.
Mm.
It cannot go beyond that.
Understand? But connecting, because that may not be applicable in your case, because that bridge was constructed by you to get the road to that.
Particular plot. That's the dead end, my lord.
That is the road.
Dead end from both sides.
Both sides. So therefore 6.6, this is your argument.
Yes.
And their case will be that it is maybe 6.6, but it is more than 250 meter or something like that when it is not to be calculated as 6.6. This is the final argument. So we'll not proceed further today.
Yes.
No, I'll place lordship.
Please. Okay.
Maps also I would like. No.
Before my learning starts, but I have
You want to-
a small point, my lord.
Okay.
Now, my lord, in this case, there is a collusion between the builder and the government.
Okay, that you have argued.
No, there are further material.
Further method, how will you see?
Yes, what had happened, my lord? For the refusal of the other benefits, we have approached invoke arbitration. Well, arbitration is going on. Now my learned friend, he is representing government in this case. Before arbitrator, he wanted to appear on behalf of the builder. Then we said, how can it happen? And this order has been passed. I'm just bringing it to lordship notice. This is one of our ground of, my lord, collusion between the builder and the government.
Then you'll have to file an affidavit.
I'll file it. Yeah. We'll file it. We'll file it.
See, you may take stand, but
Yes.
thing is that
just bringing your lordship notes.
no,
Taken
Mr. Chaudhuri, two things. See, according to these are contested matters,
Yes.
is not it? If you make any statement or anything, the other side should get a time to respond. This is one. Other part that regarding that chairman of GMDA,
Yes.
that is also not part of record. That is only a document.
Yes. No, there is no dispute. Nobody has denied that.
It is not a part of the pleading also. It is not a part of the pleading.
Anyway, my lord, I'll file a small affidavit. I'll bring that.
I think so. See, whatever,
Lordship will read the whole order.
In the midst of final argument, my lord. In the midst of final argument.
No, it's a development which has taken place after
careful,
this.
careful, careful.
Then the Lordship will may read the order.
Okay, we'll take note of this.
We'll file a small affidavit regarding that chairman part. This I am leaving into your lordship's, Mala, I am not bringing this on
Yes,
record.
this is not necessary.
Yes.
We are not.
Regarding
My
chairman,
humble
I'll file
submission
an
is-
affidavit.
Let us not go to all this.
No, Lordship may go. Lordship may go because somebody wants to hit somebody in the below the belt. I'm regretting.
No, no. Don't,
it's-
I do not like any hitting before
no,
this
no,
court. I
no,
want
no
a,
hitting, no
I
hitting.
want a
We are
sport.
all well guarded, Lordship. These type of things are very unacceptable. Anyway, I'm placing the record.
Just, you
Yes,
just
yes,
go to it.
yes.
Anyway, my lord, what we propose to do, my lord, we'll file a small
You
affidavit
file
regarding
it
the
in the-
chairman
in the-
part, I'll bring on record.
Yes, you will.
That's it.
Now,
On
this may
reopening,
also be
carry on.
brought to record. This may also. Why shying off now?
If your lordship wants, I can give tomorrow or on the reopening. Tomorrow I can
You
give.
tomorrow you file it. We
Lord,
are
yes.
keeping this matter for further hearing on 4th of
Lordship,
November.
my humble submission was that case was completed.
Mm.
2 rounds already completed. Now at this stage, why this
Let him
additional?
have. Let him have.
Let him be happy, be the happy person.
Let him
Yes,
have
let
it.
him be happy
Let
person.
him, let him have
No
it.
dis-
Let
Lordship's
him.
kind permission, can I
Yes,
take
yes,
it?
yes.
Deeply applied.
Let him be a
Just-
very
just
happy and
I-
contented person during the puja.
Yes, yes.
But I'll place this.
Guys, just I want to, because this is important. That
Yes.
is what, that's
Checklist.
why I wanted this.
I have given the original records.
One thing I just want to point out. Your lordship is the hearing has taken place. It's nearing completion. And today I really wanted to one judgment on Supreme Court, where they have never brought notice to the court across the table they have passed.
No, that's why I'm saying.
That's what I'm saying. What they have said, chairman, I mean 2019, chairman of the GMDF. Now they are bringing, said, no, we want to file an affidavit to their extent. Mano, kindly see my lordship has heard this matter totally. This is neither part of
Let him
pleading
be
nor
happy.
particulars, mind.
Yes.
Whether they, Mano, this way they will go on. go on
Therefore, I
filing
have said that this is not
Yes.
pleading. We may not like.
Yes.
See, that's why I've said. Because how can I take a?
We are not objecting, Lordship. We are open because we have nothing to hide. We have nothing to hide. At least they should have sporting spirit. They should have allowed me to appear before the arbitrator because the arbitrator, before the arbitrator, the two private issues were involved. There was no government's role at
Let
all.
us not go to that. You just show me
when
the
they,
provision
when
of
they
law.
submitted that 3 pages later, when my client, I haven't gone through the letter also. Immediately I informed my colleague counsel that informed the honorable tribunal that I am not going there also. So it is not like that, that there is any collusion.
Yes.
Otherwise, I have a direct access to the minister, being the advocate general.
That is your statutory privilege.
Absolutely. And we are now defending their interests.
See,
because we have given-
that minister
there is
might
no
have,
conflict.
I might have also meet him in an official capacity. That is a altogether different.
So that is why this hitting below the
That
belt
is
and
nothing.
taking all these things
Nothing.
doesn't look good.
These are not,
That
these are not
look
issues
good.
before this court.
Yes, absolutely. And more so when there is a holding
Yes, let
some
us- let-
responsible post like
let us-
president of the bar council, bar association.
Let us go to the bylaw.
But we have every, I think he should have been there so that I can give him back. Anyway, Lordship will kindly take this. Have Lordship taken this checklist?
Big record, lordship.
This is.
No, checklist.
Huh.
Checklist is Xerox copy?
No, original record.
Okay. Checklist Lordship will see the 3 road width of the road 8.0.
Checklist.
Yeah, there is a checklist. After that committee.
Checklist. No.
Yes.
You have flag marked the important things, na, Mr. Bora?
What's it there?
Yes, okay.
Width of the road in entry point, minimum point, maximum point. Lordship will see 8.0 meters average. Next page, and FAR, he is entitled for 2 FAR. number 5.
Hmm.
But he was given 175 at that point of time. Next page, Lordship will kindly come to fourth paragraph. In the meantime, note sheet 17.
Note sheet, in the note sheet, madam.
In the note sheet.
May I read this,
You have
Lord?
flag mark, na?
Yes.
Note sheet, 17, page 17, madam.
Page 70. It starts in page
Type
20.
copy, Lordship.
Okay, okay, I have got it.
The type copy.
Please refer to the petition submitted by Unnoyan Samiti of Torun Nagar with a direction to Deputy Chairman to stop the present work so and so and our subsequent order of so and so. Here, Lordship will kindly come to the fourth paragraph. As regard to the complaint of Samiti 439C, may be stated that due care has been taken so that the drains of this road is not obstructed by the bridge. The issue of the obstruction due to existence of 11 kV line is also proposed to be taken care of. The approach road to the bridge in Torun Nagar side is 7 meters to 8.5 meters. Lordship will note that. And is a public road and Samiti cannot restrict its use to certain localities only. The condition number 6, that is design of the ramp of our NOC at flag B, has also taken care of issues raised in the petition on the status of road after completion of bridge. In the meantime, people of Anil Nagar and other organizations of North Bank has submitted petition supporting the construction of the bridge since the bridge will enhance the connectivity between the southern and northern part of Bhorulu River and will greatly reduce the congestion on the portion of Rajgarh Road from Bhorulu Bridge to GS Road. So these are the various opinions, as because Lordship indicated the public opinion. And next page, Lordship knows this is the, I have already placed it 10th November 2009. This NOC was granted by GMDA at proposed road width 8.5 meters wide.
Okay, this is one file, na? For whole the.
No, there are another, this is GMC file. Lordship will turn to last page, Lordship. There's a horizontal papers are there.
No, this file is same for the both the parties.
It is the same one project one project only, Lordship.
Okay.
Horizontal.
The ownership has changed. Maybe there is some.
But the file is the subsequent modification.
That is why Lordship. We are saying no,
there are horizontal papers that just before the check slip, just before the check slip. Last at the
just
end.
before the horizontal paper. Yes.
These are the committee recommendations. Then there that
minutes of the
it is
recommendation.
2008.
2008.
Okay.
Next page, serial number 60. Page 413.
Page
413.
413.
Magmolar State and Services, GMDA number so and so. Ground plus 9 floor. Now existing road width 7.8 meters to 8.5 meters. Proposed road width 8.5 meters. This is of 26 December 2008. The next page 3/1/2009 414 serial number 49. Japorigo existing road 7.8 meters to 8.5 meters. Proposed road 8.5 meters, coverage 6%, etc. And signature is given at 3/1/2009. So it is, and another at 3/1/9. It is identical. So nothing is changed in the meantime except construction of the bridge.
According to you, the 8.5 width was at that point was also therefore by virtue of change of the law. He has become entitled, not for any other reason.
That is one part. That is not my final argument. My final argument is after the construction of the bridge. And these 3 maps will give more light to the whole situation. We have given the GIS map. I hope they will not because any kind of objection may come up, but these are highly sophisticated technical documents, electronic imaginary date 31/3/2014, the first Lordship. Have Lordship got it? The bridge was not there. This was a bamboo bridge.
It is 2014.
2014, imaginary date. So the bamboo bridge was.
Now, is it a new thing that going back in time travel?
No, I'm giving a subsequent.
No. Is it a time travel mechanism? Or it was taken at that point of time?
No, it was now.
Now
today also, because
no, that is what I'm saying. That Google time travel.
Yes.
Yes. Okay.
because in Kaziranga Lordship knows there is a Supreme Court judgment
Mm.
of 12 April 2020. There should be no phase construction in the eco-sensitive road zones. So if anybody is constructing one floor more also, everything
That is
can be
time
monitored.
basis.
Absolutely.
Yes.
So we can give the maps of 2010, 2011, all. These are highly technical, and I hope the other party will not object to this. Now, Lordship will kindly come to page, the next one, 28 March 2018. These are as it is in existence today. That square part, if square is to be considered, it is not considered as the road width is 12.27 meters there. And this was of 2018. Who was at the helm of affairs? The writ petitioner. Who has relinquished his land? The writ petitioner for construction of the bridge. That is why the bridge was allowed. And on the basis of which the Honorable Court directed in 2017 that under the new circumstances, reassess his affair and give it. Therefore, he got in 2018 200 affair after construction of this bridge. That or judgment also I have.
My Lord Justice Bhuya's judgment.
Yes, Lordship.
That I have already collected.
Yes, Lordship. Very clearly said. Now the bridge is here. Therefore, the authorities will look into the whole matter under the new circumstances.
That I have taken.
So
because in that judgment, all facts are
narrated, including there's objection regarding construction of the
all three writ petitions were decided together.
And finally, the Honorable Court directed that under the new situation, reassess the affair.
That is why I am saying in those writ petitions, even the challenge was to the disasters management review order.
Yes, Lord.
That was also under challenge.
Lordship.
The other challenge giving permission was also under challenge.
Absolutely.
And other writ petition was non-consideration of his representing. So these issues were already
at that point of time. Protect was not there. It was McMullen.
No, not there.
And he himself cannot turn back now. So he took all the advantages. So I hope
where is the documents regarding this new committee and all that since they are giving
Another 2 records are another 3 records are there. Total 4 records here. Only on 2009. Huge back.
So that is a good sets of homework, Lordship.
GMC record.
We'll hand over.
Mr. Bora, here more or less we have found that this proceeding of that mega molder is up to which period this record?
This is 2009. These are the latest.
I want that period between entering between their agreement and up to their final, which is under challenge.
There is another record also I am handing over for GMC. These are all GMD records.
Okay, we'll look into just you complete
Now,
it.
the 2006 bylaws. Now, when there are 2 roads or more, wider road to be considered bylaw 38. Building abutting on 2 streets. If a building is situated on 2 or more streets of different width, the building shall be deemed to for the purpose of those bylaws to face the streets which has the greater width and the height will be as per bylaws. So 38. Now 14. Next page, Lordship. This clause of proposed road width is not applicable for dead-end road as applicable of roads of more than 250. The 2013 disease report very clearly says the road width, the length of the dead-end road is more than 450 meters, according to their submission. So here, that 250 meters bar is there. So, Lordship will kindly come to bylaws 21. Various parameters are given. This will not be for private roads, cul-de-sac, and for those authorities will decide the width based on the length. For dead-end roads up to 250 meters in length, proposed width is 6.6. So here this clause will not come into play because the length of the dead-end road is more than 450 meters and not restricted up to 250 or less than 250. So it is considered as a regular road. So that dead-end concept will not be applicable in the present situation. For dead-end roads up to 250 meters in length, proposed width will be 6.6. So beyond that, it is a regular road. . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . itu করতে হবে 415 টা না 415 রেকর্ড হবে Even today, the road is more than 450 meters towards Jew Road. So now FAR for roads widths above 8.5 to 15 meters is 200. So this is the amendment part. Residential building, commercial building, etc. Up in 2014 bylaws is 8.8 meters to 15 meters is 200 FAR. So relevant law bylaw will be 26. Next page, the chart is given. Base FAR 150 in red color. Above 8 meters to 15 meters, 200, and height, there is no restriction. Plot of the size above 6690 square meter. Another point which arose, when there are two streets wider to be considered not Anil Nagar Road in all access road area of Tarun Nagar considered as per the approved plan of GMDA. All along it was the Tarun Nagar Road which was considered. Anil Nagar Road was never considered at any point of time, whether it is in 2009, 2016, 2018, 2020. In all four NOCs and permits lordship, the Tarun Nagar Road was only considered. Out of the four permits, three permissions he received, all on the basis of Tarun Nagar. And that is done as per the provisions of the bylaws. That the widest road will be considered. Here, three roads they are indicating. One is Anil Nagar Road, one is Hinduri Pot, the behind road. That was their argument. And the third one is Tarun Nagar. So Tarun Nagar is the widest, so that was considered, and it ended in front of the project. Then under the 2014 bylaws, bylaw 29 says, if a building is situated on two or more streets of different widths, the building shall be deemed for the purpose of these bylaws to face the streets which have the greater width, and the height of the building shall be as per bylaws. So it was a repetition of the 2006. How to calculate the width of a street? Bylaws 26(3). A. The width of a street means the clear average width of the existing carriageway and the footpath and the drains only on which the building or plot abuts. The minimum width of this existing and the proposed widths prescribed by the authority will be taken for calculating the maximum permissible height of building. The average width shall be computed by taking the width of the road at the last junction point leading to the plot. So last junction point is 12 point decent. The other is 8.1. In front of the plot and at the point where the road width is minimum, that is 4.5, the bridge, the minimum was 4.5. In cases where the width of the street road is not regular or uniform, all along the length of the road, provided the minimum road width is available at entry point in front of the plot and some other 2 points. So we cannot choose any point of our fancy. Whatever is there under the bylaws 626(3), 3 points has to be taken to find out the average width. Precisely this has been done. And in his case also it was only done. When he applied in 2016 to get 200 FAR, the bridge was already in position, and therefore the various 3 points were taken at that point of time to grant him 200 FAR. Relinquishment is permissible. That lordship will find bylaws 121. Additional FAR for widening of roads, improvement of junctions, laying out of new roads, open spaces, public amenities as proposed in the master plan. The plot land reserved for road widening, junction improvement. Here it is junction improvement. Propose new roads, open spaces, public amenities, and other public purposes as identified in the master plan or development scheme shall be considered for awarding additional FAR, provided the owner surrenders the part of the land so reserved to the authority free of cost and free of any encumbrances. So if Lordship is pleased to look at the 2018 map, the land was given already. He has done it. And it is permissible under the bylaws. And that opinion was given in the Deputy Commissioner's report also. Now 2020 bylaws, what is the change here? Got FAR of 275 on road above 8 meters, which can be 800.801 millimeter, that is a fraction of 1 millimeter, because the changes in building bylaws where FAR increased. So this is my case. On behalf of the GMDA, we are compelled and we are bound by this bylaw unless this particular provision is challenged. So the road width is more than 8.00. It had been 8.001 also, we'll have to give 275, considering the area of the building that is beyond 10 bighas, and the road width is beyond 8 meters, then Lordship, we are bound to give him. If the land is less than 10 bigha, it is 225. If it is more than 10 bighas, it is 275. So amendment of the bylaws 26. So here, Lordship will find at serial number, second last. Above 8.0 up to 15 is 225, and plot size above 1300 380 square meters 10 bighas is 275. Have Lordship got it?
Yes.
It was not the panel, the second from below.
Above 8
Yes.
up to 15.
Yes. Now the central government is giving us incentives. Next page, Government of India's guidelines to increase FAR. That guideline also I'm placing it before the honorable court, but we have not accepted this guideline at till date. At present, the maximum FAR, next page, Lordship. These are the guidelines of the central government. At present, the maximum FAR permissible is 300, and in transit-oriented development corridors, FAR is 400. Government of India, Ministry of Finance, Department of Expenditure had issued a guidelines on schemes for special assistance to state for capital investment of 2024-25. In this guideline, in part 5, reform 3, states will be eligible for incentive of 200 crores upon notifying changes in regulations to increase the base FAR of all commercial buildings in municipal and development areas to at least 5, and increase the base FAR of all commercial buildings in central business district and transit-oriented development corridor. So the intention of the Government of India is now that give more FAR so that the commercial activities increase. But we are not accepting this considering our situation. But if we implement it, for every reform implementation, we are getting 200 crores, which is a big money. But we are not accepting till this. So all these changes are being done because of there are certain norms which are propounded by the Urban Affairs Department. So my humble submission is that the law is well settled here.
Yes.
The road which was considered for calculation of the FAR and the road width was all along the Tarun Nagar.
Yes.
Was
Yes.
all along Tarun Nagar Road. It was never Anil Nagar Road or the other side of the road or the behind road. The law says whichever road is maximum width, having maximum width.
Just a minute. Yes, I'll keep this in a separate thing so that I don't miss it. You have already dictated 11 pages of the judgment regarding that your arguments or everybody's argument. So
Right, and that's why I'm not repeating anything except saying that
this is
whether it is he is a minister, he is a chairman, he is a MLA, this has nothing to do with the provisions of the law and its implementation. So far as JMDA is concerned, we have different ministers at different point of time. If we look at the ministers from 2008 onwards, how many ministers of the urban affairs have changed? They have no control over this, whether he's a minister or a chairman. Everybody is bound, including us, the authorities. And Lordship will also implement,
We'll see into the provisions of law.
Provisions of law and nothing
upon
else.
the record, whether
Whether it
these are
is Mr.
satisfied.
Saikia or Mr. Jalan, that has nothing to do. So
We may go to that extent when we have found that there is tweaks and turns at
Absolutely.
base of somebody, then we'll go to that aspect of
yes,
them.
Lordship.
First, we'll have our satisfaction that this is done as per bylaw, as these are the bylaws, these are the provision, these are the records.
So my
Then
vote was
we'll-
very limited, placing the law as it is before this honorable court, and Lordship will implement it and give the opinion on that. This is my humble submission, and my submission regarding chairman or vice chairman or Lordship the minister, we are not bound by any of their positions. And everything is under
Of
public
course.
domain and public scrutiny and judicial scrutiny too.
Mm.
In that situation, no government officials will risk their career. And more so when there are standing orders of the Honorable Division Bench of this Honorable Court, that if any officers is found to do any kind of mischief in giving FIR or building height permissions, they will be strictly compelled for going under departmental proceedings. Lordship knows those judgments. I don't have to produce that. Series of instances had happened in 2008, 9, 10, 11
This is
onward.
the peak
Series-
period of demolition.
Yes. During that time, this Honorable Court have on several occasions passed those directions. So no officer will take that risk of his service career and also facing criminal prosecutions.
In fact, there was a sumoto PIL in that regard.
Yes,
It was a
Lordship.
continuing.
This one, the officer had to run from the court number 1, that old building, straightway to Delhi. Lordship, remember this? That 5th floor building in Ujan Bajar.
Yes.
And the
I was-
Priyanka building.
I was the counsel.
What more do I need
We
to say?
went to Supreme Court, then Supreme Court granted permission that he continue subject to final outcome. Building was completed,
But
then
he,
it was.
he was about to be arrested
Yes,
in
yes.
court number 1.
Yes.
Lordship remembers
Yes.
that. How he ran away, we saw. But same with Priyanka building in Panbajar. Whole top floor was demolished, huge loss, but government did not budge. Highly obliged, Lord.
Yes.
Lordship, I'll hand over the GMC record also. Another record.
See, basically, why we want to see the record is the fundamental allegation is that this has been twisted. So we'll see the record, on what basis they have given the permission.
Yes.
That's all. So therefore, that record I want. I do not want to go to every.
That record will be
That this is that I have
yes,
seen. So
one
relating
record
to
which
him,
will be very
I
limited.
want subsequently
That 2020.
2020.
That inspection report, I have placed it in our affidavit also, that report is
And
there.
that record is how it is proceeded. That is there.
Lord.
Okay.
Three records.
That's all.
That the Mandal to Mandal's names are also given.
How they have
The
proceeded.
circle officers' names are given, and the 3 officers
Since
who were
it's a
part of the
writ of certiorari, it is a certifying the record. So therefore, actually in all certiorari cases,
Yes.
we should peruse the record.
Yes, Lord.
It's a certification of the record, isn't it? This writ of certiorari is certification of that.
Lordship.
Heard the learned counsel for extensively. List this matter on further hearing on 4th
4th of November. Highly obliged.
4th is after Monday, na? Huh? Then I give it on 5th. Yes, Sarma, tell us.
Approved it.
Approved it. Fine. That's we know that you have approved it. Yes, he has approved it.
One more prayer is there, your lordship.
Oh, then other prayer will examine after vacation.
Lordship, today also I am not in it.
It is submitted by Mr. Sarma that pursuant to this Sarma that board of directors on board of director of Assam Fisheries Development Corporation Limited in its meeting held on 9/8/2024, the prayer of the petitioner as regards remission, isn't it?
Yes.
In respect of the kist of Silosi Bill of Borpeta district has already been approved as resolution number 3 and the resolution number 13. Learned counsel for the petitioner submits that though that another issue is still required to be adjudicated in this writ petition, that is
Cancellation.
Huh?
Cancellation of settlement. your lordship.
that is the cancellation of the settlement in favor of the petitioner. First up, Mr. Sharma, learned counsel submitted can be granted some time to prepare the matter. Accordingly, list this matter on 25th of October 2020.
Not 20, later, but
You take a decision.
29, the last part of
29th of October 2024. The communication addressed to Mr. Sharma as regards the resolution of the Board of Directors meeting dated 9/8/2024 is kept on record.
Item 30.
7 to 18.
Yes.
Learned counsel might come.
Have you taken any instruction from your senior?
It might.
You ought to have taken, yes. On the prayer of the learned counsel for the parties, list this matter on 5th of November 2024.
57.
See, madam, what is your express urgency? Tell us.
One lady's waist was broken.
Mm.
She and her 2 minor children have been starved and they are undergoing starvation. Yesterday, I raised some fund.
No, forget about now. What is your prayer? What is the difficulty?
Admitted.
No, this matter. This matter admission is not very important. Important is what kind of interim order you want.
For the
Your whole case grievance is that non-notification of the magistrate.
one part.
One part. And other part?
The other part is that there has to be a place where the victims and the perpetrators could go. For example, there is a medical board.
Whether that are in place.
The medical board is in place.
Then?
But they do not have any instruction or guidelines to entertain the examination of the patients. Meanwhile, all sorts of
what the Act says? What is the provision of issuance of guideline under the Act?
The Act is extensive.
So therefore, what is a separate guideline you require?
Separate guidelines because
no, your wanting or not wanting is not the issue.
No, it's not me. It's not me. After the parliament has enacted, nobody will comment on the parliament. But it is upon the courts to have the guidelines for implementation of the same.
No.
So
the parliament in its wisdom has framed an act.
Yes.
And it is an extensive act. And that has been...
Many of the things since 2017 have evolved. Lots and lots of medical records have come in. Lots of research have come in.
For you come to the specific instances. Where is the lacuna that you are saying medical board? Medical board is already on place.
The home department, the police needs to be instructed. They need to be aware of it. They have powers within the act. There should be the ambulances should be specially trained.
Under which provision?
Sorry, paramedical.
So what is your case? You want to say that
I want to say, my lord, just for one.
What is your prayer?
At this very moment, we do not even have a government-owned facility where this kind of patients can be admitted.
Where is the prescription of the under the act that these patients should be given a special hospital? Where is the provision?
Under the act. So.
No, please tell us.
No, what?
No, you'll have to tell us. Then we'll have.
What? My lord is
see,
asking
you'll have to,
so many
madam,
questions,
arguing a
my
case is saying your stories is a different thing,
My
and
lord,
arguing before courts of law is a different thing. Listen, please listen. Parliament annexed an act prescribing certain things. You may come to this court saying that this is the prescription. This is mandated that there should be a special hospital or special center. This is the prescription of the act or rules. and that has not been created. This is one way. Then we can pass an order. But as you are arguing, as if you are saying to legislate us. Okay. So first you are saying this is not there, this is not there. Where is the prescription? You have to say that, my lord, this is the provision, this is prescribed under Dex, so and so, so and so. This is not in place in Assam. Tell us.
If I may, that is what I was going to.
Yes, tell us.
Whatever your honor is saying,
Mm.
that's all that we want. For example, I said about the paramedicals. If the paramedicals are trained.
Where is the prescription of paramedical? Please first tell us.
Using.
No, please, madam, please listen. You just tell us that these are the provisions of this act. First, let us understand. And these are not been implemented. You show us that. What are the provisions not implemented?
What are the provisions? I'll just get my big file.
Mr. Gogoi, sum and substance is rule is not framed. Okay. So rule is to be framed.
It will take some.
It will take some time.
One thing, Lordship may kindly have a look at the prayer for a moment, my lord.
That's why I'm saying.
Lordship is repeatedly saying, my lord, to all the parties, my lord, that not to take it as an adversary litigation. In fact, my lord, if you go by the limited prayer, it's only related to the petitioner only. Whereas Lordship is looking at the public interest.
I am looking at it because
it will take some time, my lord.
It will definitely.
Yes.
There is no. We cannot fix a date for the government to frame a rule. That exercise will not do.
Yes, my lord.
Basically, her first day's argument was that magistrate is not notified. But if we go through the rules, magistrate notification is not even required, because the chief judicial magistrate in a metropolitan area and other magistrate in such and such area shall, by virtue of the act, automatically act as the magistrate under this act. Only in case of the one magistrate first class is empowered, then only notification is required. So where is the question? She has not read properly. Problem is this.
Delegated, my lord.
See, that notification will required when it is not CJM or a other sub-divisional judicial magistrate. When it is only a first class magistrate, suppose in a place government want to entrust the first class magistrate to exercise the power under this act, then only notification will be necessary. She is presenting it like that no magistrate has been appointed. It is by virtue of the act, section 2L2. It says CJM or any other magistrate. So this is not understanding what she is arguing. Sorry to say that.
Posted on, my lord, immediately after.
Mr. Gogoi, take it. This is an important legislation.
I'm pursuing with the authorities.
It will take time. We know that because we are pursuing in a division bench to formulate the policy of the juvenile justice that we are not having. So you will give some time.
But
in a course of law, you will have to see principle of law is we are not legislating here, except in exceptional circumstances where there is vacuum. Here we can pass some direction. Here the parliament has enacted an act for the interest of the for the purpose of this person, Mental Health Act 2017. It is a comprehensive act. It prescribes certain rights of those persons. Okay, some rights are created of those persons, and for application of this act, a rule making power is given, and therefore rule is to be made. Now, if you come to the court that I want this, I want that, first thing first, you'll have to establish that under this act, I am having this right. So therefore, you'll have to go to the relevant provision of the act that this is the section so and so, which prescribes that there should be a special medical unit in every district of every talukas or every so and so. You will have to go through. You are not having with the on the prayer of the Mr. Gogoi. Matters adjourned and will stay on
28th of October.
28th of October. 20, not 20. It will be the second part of November.
Oh, yes. On 11.
On 11th of November. Yes. One. Okay. Yes, Mr.
My lord, here, my lord, on two counts. I'll be very cryptic, my lord. Here, what has happened, my lord, on the factual part of it, my factual metrics, my lord.
They have considered that there is severe glaring.
I'll take only 1 minute on that, my lord. Kindly see, my lord, in a case where somebody's land is mortgaged, then loan is sanctioned, my lord. What the investigating agencies to do first is go to the bankment, my lord, and the sanctioning officer or officials, my lord. They never did that. So that is why, with all respect and tolerance, my lord, what happened? Loan was granted in the name of a fake person, my lord, who was not even the landowner, my lord. That investigation should have been started from the bank itself, my lord. The banker who gave the loan, or whatever be the nomenclature, my lord. And down below the officials, my lord, clerk to the extent of clerks, my lord. So it was a manipulation of the highest order to the extent that it was given to a non-entity because the entity has not been found out. Even the officials of the bank who granted the loan, my lord, they were never examined, my lord. Have I made my position clear, my lord?
Yes.
So this is the situation, my lord. And definitely, my lord, one report came. I'll be very cryptic, my lord, on the factual metrics, my lord. This report, my lord, if it is read, my lord, it is dated 2919, my lord.
Where do you get that in a record?
May just basically, and it will be easier. It will be more again. If it is read, my lord, in 19, my lord, they came to the conclusion what they achieved, my lord.
Okay, okay.
This is the, my lord. But here also no mention that, my lord, nobody was examined, my lord. I should not say, my lord. Possibly police was in hand, Sanmari police was in hand. One part of it, my lord. Secondly, my lord, that, my lord, when such a situation arises, my lord, the law is very clear. Lordship knows more than me. My lord, that's Sirkari Bostu.
No, we know nothing.
No, my lord, Lordship. Lordship quoted Sirkari
We see
Bostu.
it here as knowing nothing. Then only we can.
Only this thing, my lord,
Yes.
as I do understand, my lord, we agitated Sirkari Bostu. We carried it out, my lord, to the hilt, my lord. Several reports. Then the diary got lost. So, my lord, connivance, I should not say it, that would be a very, I mean, possibly a harsher word, my lord. Something was missing, my lord. Then it was reconstructed, my lord. And suddenly, out of the blue, despite the existence of this report by some other official, my lord, the chain got broken, my lord. First chain of culprits gone. Second line came up, maybe a good officer, my lord. This happened. Suddenly, my lord, the final report has been granted or placed. Either granted would be a wrong term, my lord. Placed, my lord, possibly by, my lord, a case of this magnitude, 65 lakhs or 56 lakhs, my lord, by a probationary sub-inspector of police, my lord.
Okay.
So this is the, my lord, can I just please sit? My
Yes,
lord?
yes.
It will be good.
No, you can, if you say the dates, I can take it out also in the orders.
Yes.
It is passed in this case only.
Yes, my lord, on 3524, my lord.
Just a minute. I'll just flag mark the first order. 29 is already here. Give it to give it back to Mr. Mahajan.
Thereafter, my lord, with all respect, my lord, let us not the in between orders, my lord. Order dated 3524 this year, my lord, in the month of May, my lord. When the final report was submitted, my lord.
Just a minute. 20.
3524, my lord.
3524. There is an order 22.5. Then
Oh, I'm sorry, my lord. Order may not be that, my lord. It is the commissioner's letter dated 3524. That is on record, my lord.
okay, okay, that is commissioner's report, is not it?
Yes.
Dated
3524, my lord.
6 March 19.
Well,
Just a minute. If it is here, yes, 35. Yes.
Exactly.
Yes.
Well, if it is read, my lord, seen that at the last two lines, my lord, already has been completed and closure report FR was filed by 109 dated on 24. A copy of report received from the officer in charge Sanmari PS is enclosed herewith as a ready reference, my lord. This is by the DCP, my lord. I turn the page, my lord. Thereafter, my lord, the last paragraph of the second page, my lord. On 25/4/24, the case was closed due to insufficient evidence. Whether any attempt was made to collect evidence that is apparent on face of the record, my lord. By the investigator.
Record says that already it was not his signature.
No, if
No, but the
that is
earlier
FSL part of it.
FSL part. So there
For
is some
FSL part,
there is some evidence.
but evidence, my lord,
They are
to
saying
unearth it.
evidence.
Exactly. I don't know, my lord. This is I catching, my lord. Lordship has got another point, my lord. I have understood. Have I made my position? Your lordship is very correct, my lord. FSL says not
It is not his
signature.
signature.
Then said that there is
the
no
whole case in a mortgage.
absolutely.
Nothing more is because you will have to sign this.
Also, absolutely in totality with me, my lord. And my lord, this is
And
the
now this, what you want to say from this? This is one point. Another.
This is one. Second point is it has been submitted because he would be knowing, my lord. These are SR cases, my lord. Some officer of some rank, some experience are given that, my lord. It is in the police manual or some administrative orders, my lord. Here, FR has been submitted to the best of my knowledge and understanding, my lord.
Who said when this FR was submitted?
On 25/4/24, my lord, this year.
Who is this officer?
My lord, WSI.
Who is the
probationary Sipra Sarkar.
Who is the IO? Please take the name of this. Correct the name of this person.
Then Lordship Punjab and Haina, I could listen judgment, Lordship.
Yes.
Lordship.
I have understood.
Lordship, I have also Lordship. Yes,
Yeah, my lord.
on Friday probably that come, Lordship. On Friday
He
probably.
is very after me. He is very. He is honest enough, man. Can I just say one?
It's necessary.
Can I just say one thing, my lord? This is the factual part of it. Now, my lord, in my understanding as a student of law, to be very honest, my lord, this Calcutta High Court, my lord, normally every case is given to CBI, my lord, and lordship knows what Apex Court has said, my lord. If it is handed over, it has to be a reasoned order, my lord.
Yes. That is why I am saying.
Not exactly, my lord. That is the law in India, my lord. In the criminal justice.
Not on mayor asking.
No, your lordship is absolutely correct. But I'm not saying that it should go to Central Bureau of Investigation. I'm not saying that, my lord. There is one authority that is tailor-made for us, my lord. Here another question arises, my lord, with all respect, my lord. In a given case, as a student of law, this is my understanding of the matter, my lord. This case is compartmentalized into a different category because the reason that FR has been said, FF has been submitted. FF in the form of FF can include charge sheet and final report both. Here FR has been submitted. Several authorities are there on the point, my lord, regarding closure report, regarding charge sheet also. Even in a charge sheeted case, it can be handed over to CBI, my lord.
Yes.
Charge sheeted, the difference, my lord. And in a cases of closure report, it can definitely be granted, my lord, if there are lapses in investigation, my lord. Now, my lord,
and this matter started in the year 2015.
Yes.
Writ petition filed thereafter, and now they file final form in the year 29/5/2024, saying that there is no evidence, whereas this court has recorded that this is the findings of the forensic.
Even Lordship, shockingly Lordship, from 2019, nothing was there. 2019, earlier I was transferred. After that, suddenly that particular IOS come and submitted the FR. Nothing, no progress, no investigation.
Therefore, you take note of the name of the.
I got it.
Now, my lord, as he is, my lord, his role is very correct, my lord. Only fair play and justice, my lord. Exactly, he has done that, my lord. In such a given situation, my lord, I'm not saying Central Bureau of Investigation, my lord, any competent agency, my lord. Why? Because the reason, my lord, he has also agreed, my lord. In a case of this nature, my lord, when a judge's wife, possibly, my lord, that Jharkhand. Mandakini, my lord. That Mandakini case is, my lord, Chhattisgarh, my lord. Some judges, somebody was relative, somebody was annihilated, my lord.
District judge wife was lost.
Yes,
Exactly.
understand.
Exactly. There, my lord, the proposition of law I am saying, my lord. There, my lord, lordship would kindly have a look at, because when he agrees, my lord, because he had access to the case diary, my lord, he looked into it page-wise, my lord. Thereafter, he is of the understanding, he cannot be of an opinion, my lord, Lord Supreme can form an opinion. He is of the understanding that this is a case where it needs at least de novo investigation, my lord. Have I made my question
Yes,
clear, my lord?
yes.
So, this should be a fit case, because in the instant case, Tushar Mehta, my lord, when it went to the apex court, he had the same views like him, my lord. There is a fit case where it should go to some other agency, my lord, because of the deficiency in investigation by the state police, my lord. And that occurs at, my lord, para 4 and 8. Para 11, I'm sorry, my lord, para 11. Only on that count, my lord,
yes.
when state agrees, my lord. Para 11, my lord.
Yes.
Lordship has found, my lord.
Yes.
So, when we are in tandem, my lord, with all respect, my lord, regarding deficiency in investigation, my lord, possibly it should go to some other agency, my lord. And now I'll place as I do understand.
Yes, yes, proceed.
What I'm that's my understanding, my lord. That, my lord, in a case where FF has been submitted, my lord, whether it can be handed over to some other agency or not, tailor-made, my lord, authorities, my lord, of the apex court, my lord. This is, my lord, 2020, my lord. Nitu Kumar Nagesh, my lord. Page 777, my lord. There I'd be very cryptic, my lord, that final form was submitted, my lord.
Paragraph?
That occurs at para 5, my lord. Regarding final form, my lord, closure report. They use the term closure report, my lord. Paragraph 5, my lord, that at the end of the paragraph, third line from down below, my lord, para 5. The investigating officer, therefore.
Paragraph?
Paragraph 5, my lord.
Yes, the husband of deputy.
Exactly, the husband. Thereafter, my lord, we go down below, my lord. Last 3 lines of the paragraph, my lord. The investigating officer, thereafter, in hot haste, has filed a closure report. I'll not go beyond this, my lord. Closure report meaning thereby, like our case, my lord,
Yes, yes.
a final form was submitted to the tune of, my lord, with all respect, my lord. Final report, my lord. Have I made my question? Again, it occurs at para 9, my lord. Para 9, towards the end, my lord. The last 5 lines, my lord. Since a closure report has been submitted, which we are being persuaded not to accept. So, my lord.
Paragraph then?
Paragraph 9, my lord.
Okay.
Paragraph 9, my lord, paragraph 9, first, second, third, fourth, fifth, sixth, seventh line from down below, my lord. Since a closure report has been submitted, which we are being persuaded not to accept. Have I made my position clear, my lord? It's not the landed magistrate down below, my lord. Why I'm saying this, my lord? If a reasoned order is passed, my lord, normally the procedure is, my lord, to Naraji, we file Naraji, my lord. But Naraji would be, I mean, in the fitness of things, my lord, that would end in nowhere, my lord, because the reason there, Sirkari Basu was attempted, we failed. Have I made my position clear, my lord? So it can be, Article 141, it is apparent on face of the record, my lord, even a higher court, writ court, my lord, with all respect, my lord, despite it being a closure report, by not taking, my lord, digging into the, my lord, the statute, my lord, 156, my lord, it can straight away do the needful by not accepting the report, my lord. First, report has to be rejected, my lord. Have I made my position clear, my lord?
Yes.
The closure report goes, my lord. Thereafter, my lord, the deficiency, as he has pointed out, my lord, we are in tandem, my lord. It has to go to some other agency, my lord. And here itself, my lord, in this case, with all respect, my lord, in Lordship would kindly have a look at para 41.7.
The principle is restated.
Yeah, yes, my lord. 41.7, my lord. In a case of closure report also, my lord. 41.7, my lord, if your lordship has found, my lord. In appropriate cases, even if charge sheet is filed, Lordship has seen, my lord. Charge sheet is filed, it is often for this court or even for the High Court to direct either the apex court or your lordships, my lord, to direct investigation of the case to be handed over to CBI or to any other independent agency in order to do complete justice. So, your lordship is empowered, vested with powers, my lord, given in such a situation, and some other authorities buttressing the same facts, my lord, same issues, my lord. This is, my lord, with all respect, my lord, Puja Pal. This is 2016, and this is the Harbinger, possibly, my lord. Lordship, but can we have a look at para 78, my lord? Oh, sorry. Paragraph 7. Paragraph 78, my lord. 78 to I'm taking a minute. Yes. 78 times. Lordship has found, my lord. The court dealing with
this court, okay, dealing with
this court dealing with the proposition that once a charge sheet is filed, it would be then exclusively in the domain of the competent court to deal with the case on merits in accordance with law, and that the monitoring of the investigation would cease in all respect, held in particular in so Rajendran, in reiteration of the enunciations aforestated, that though it is ordinarily so, the power of transferring investigation in rare and exceptional cases for the purpose of doing justice between the parties and to instill confidence in the public mind can be met invoking its constitutional power available to ensure a fair and honest and competent investigation. So thereafter, my lord, that Naraji part goes. Naraji part, with all respect and tolerance, my lord. Thereafter, I come to para 79, my lord. The presidential ordainments against absolute prohibition for assignment of investigation to any impartial agency like CBI, submission of charge sheet by the normal investigating agency in law notwithstanding, albeit in an exceptional fact situation warranting such initiative, in order to secure a fair, honest, and complete investigation and to consolidate the confidence of the victim within bracket as victims, and to the public in generality, just administering mechanism is thus unquestionably absolute and hallowed by time. Such a measure, beautiful language, my lord, such a measure, however, can by no means be a matter of course or routine, but has to be essentially adopted in order to live up.
I have said it cannot be a matter of routine, but
Exactly, in exception. Is it not an exception?
Yes.
This is my lord. Thereafter, I need not proceed so far as this authority is concerned. There is another authority exactly on the same line. I'll be very cryptic, my lord. This is, my lord, with all respect, my lord, Anand Kumar Karmuse, my lord. There I read para 14, my lord.
Paragraph?
Para 14 primarily, my lord. 14, what about that? I'm taking a minute.
47. 47?
Yeah, I'm taking a minute. I'm sorry, my lord. There are 14. How come it go? My lord, here also, my lord, para 47. Lordship is correct. Yes, because I wrongly I said. I leave the first page, my lord, 47. I turn it, my lord. Thereafter, I'll be very cryptic, my lord. Here to stand there. Proper, fair, reading between the lines, my lord. Proper, fair, and impartial and effective investigation, eroding its credence and reliability, is the precondition for a direction for further investigation or re-investigation, submission of the charge sheet ipso facto, or the pendency of trial. Even during trial, it can be done. Trial can by no means be a prohibitive impediment. The contextual facts and attendant circumstances have to be singularly evaluated and analyzed to decide the needfulness of further investigation or re-investigation. because reinvestigation was never visualized under section 178, my lord. Only 178, my lord, further investigation, my lord. Here the word has been used, my lord, further investigation and prior to that reinvestigation, my lord. Further investigation or reinvestigation to unravel the truth and mete out justice to the parties. The prime concern and the endeavor of the court of law should be to secure justice on the basis of true facts, which ought to be unearthed through a committed, resolved, and competent investigating agency, my lord. This is one, my lord. And thereafter, my lord, this is my lord, Vinay Tyagi, my lord. Vinay Tyagi, my lord. I am reading para 33 and 34. Listen, my lord. I'm sorry, my lord. Yeah. Well, I'm reading it and I'm placing it before your lordships, my lord. Para 33.
There are 13.
There are 33, my lord.
33.
Lordship, my lord.
Yes.
At this stage,
Yes.
at this stage, we may also state another well-settled canon of criminal jurisprudence, that the superior courts have the jurisdiction under section 482 of the code or even article 226 of the Constitution of India to direct further investigation, phrase or de novo, or and even reinvestigation. Phrase, de novo, reinvestigation are synonymous expressions, and their result in law would be the same. The superior courts are even vested with the powers of transferring investigation from one agency to another, provided the ends of justice so demand such actions. Of course, it is also a settled principle that this power has to be exercised by the superior courts very sparingly and with great circumspection. It's a case possibly it falls in the category of sparingly. With all respect, my lord. My lord, again, para 34. I did not have to read, my lord. I'm leaving aside 10 lines from the top, my lord. It can safely be stated and concluded that an appropriate case, when the court feels that the investigation by the police authority is not in the proper direction, and that in order to do complete justice and where the facts of the case demand, it is always open to the court to hand over the investigation to a specialized agency, my lord. To a specialized agency, my lord. But I'm taking a minute, my lord. My lord, this much, my lord. Here, it has been handed over, my lord. This goes, my lord. There is another one, my lord, with all respect, my lord. Here, my lord, with all respect, my lord. This is Central Bureau of Investigation versus Hemendra Reddy, my lord. Here I read para 77, my lord. 77, my lord. On the point that, my lord, when the FR has been submitted, my lord, we may summarize our final conclusion as under. Lordship has found, my lord, with all respect and full reverence, my lord, even after the final report is laid before the magistrate and is accepted, it is permissible for the investigating agency to carry out further investigation in the case. In other words, there is no bar against conducting further investigation under section 173(8) of the Code of Criminal Procedure after the final report submitted under section 172 CRPC has been accepted. My lord, it is if they do it on their own.
We can, yes.
But here is a case, definitely they will not do in their own because they have said.
Your argument is that it is a constitutional court which will have no
Exactly. That goes
restriction on power.
Yes, I'll take one more line, my lord. prior to carrying out further investigation under section 178 of the CRPC, it is not necessary that the order accepting the final report should be reviewed, recalled, or quashed. So in that given situation, my lord, even despite there being a final report, my lord, despite it being quashed, even in that event, de novo investigation or whatever be it, my lord, that can be allowed, my lord. This is with all respect, my lord.
Lordship, I will answer her yes, die along with Lordship, short note as per Lordship direction. And even Lordship regarding a lapses part also, I have that part Lordship.
Heard in part, this matter for further hearing on.
My lord, yes, any day, my lord.
29th October.
No, not 20. It will not be this month, November.
Fine.
Give a date on November. Huh? He will give a date. 20. No, it will go beyond. Part third cannot be till 20. It will be at based on third or fourth.
Now, normally, my lord, aspersions are not cast on the police. It should not be cast also. But here is a case, at least some direction should to go that these sort of things never happen. Because despite the existence of forensic report, they say no evidence.
Lordship, I hand over the CD.
Yes. On fourth.
Lordship may segregate.
Third is a holiday.
Lordship may segregate second matter. Because
Okay, list this matter for furthering on fifth. On you don't have problem on
No,
fourth.
no, I have no.
Fourth and other on fifth. Okay.
Highly obliged.
Fifth.
Highly obliged.
Lordship, may I make a small prayer, Lordship?
Yes.
In item number 59, Lordship, I have said that the interim order is still today, it may be extended. Interim order was the further order.
Item 59. We need not pass that order.
pass
Just
that part,
note it down. Interim order need not be extended. Item 59. Yes.
Item 49, Lordship.
The interim order is still further order.
Okay.
In item 49, Lordship has asked to file an affidavit. Here the home was desealed, but the affidavit could not be filed by the SP, Lordship. We have received the instructions, Lordship, that
What order we have passed already?
the premises, it has been desealed as per my instruction, it has been desealed on 26.
But my lord, actually this premises was sealed, but again locked by the police and said that a committee will be formed. And they have decided whether the material should be seized or not.
When it had happened?
25th or
26th.
It has been desealed.
Desealed, but again police locked and like keep the case in the hands of the police and said that a
What is
committee
it?
will be
Because it
formed.
was sealed by the district administration. I think because of some materials
Who
inside.
have asked you take the material?
Lordship.
They said that a committee will be
But
formed
that
and they
instruction
will
was-
decide whether the material will be seized or not.
That was not.
What committee? We do not know.
That was not my instruction.
You have it tomorrow. You have the instruction. Let
Lordship.
it matter tomorrow. You have that. Forget about your affidavit. You have that instruction.
Lordship.
Forget about committee.
Okay.
You deseal it, hand it over. You take those. What committee?
That instruction.
Yes. So therefore, since he has said, item 49. Though Mr. Roy submits that pursuant to this court's earlier order dated so, the sealed house of the petitioner has been desealed. However, the learned counsel for the petitioner submits that though the house was desealed, however, the police investigating authority has again put a lock and key in the premises on the pretext that a committee shall be constituted to taking a call as regards the material inside the material that are fixed inside the committee. At this stage, Mr. Roy submits that he will obtain instruction by tomorrow.
Otherwise
Please
the-
this matter tomorrow.
Otherwise, the case has been FR.
Understand, but case is FR, then now you have desealed after this court's order. We are not sparing you. Maybe Deputy Commissioner. You will have to pay compensation. What is this?
Lordship, I take means.
You will seal a house, keep it until court passes an order. Every day's rent you will have to pay. Mind it if necessary from Deputy Commissioner's pocket.
Lordship, item number 2, can it be after 6th of November? Any date, Lordship?
6th of November, give a date. This matter will take, please dictate this order. Yes, how many matters are left?
18.
Yes, how many matters are? Yes, Mr. Dasgupta. Act 2? Only one, your matter is left? And any other matter? Hearing? At 49, okay. So only your matters, at 2, welcome.
The Contracting Council in Court number 70 for judgment melody. After 2 minutes, madam.
We do not know. If we enter into the hearing, we do not know. Next. Yes. Record it. We are going for the final hearing today?
Subject to lordship convenience, of course.
No, we don't have any problem.
Look, basically, we have challenged an award passed by the Labor Court. The award is at page 15. May I read this award?
Page 50. Now, what was the dispute?
The dispute is a dismissal.
Huh?
Dismissal of two workmen, tea garden workmen. They were
The dispute regards to
dismissal of two
garden workers.
Two garden workers. Now, one of them is the vice president of the union, and the other is the general secretary of the union. Basically,
Now, that was challenged. Now, on what ground the learned tribunal has answered the reference against you?
because initially, initially, the award was challenged on the ground. First round of litigation was that. Though I was dismissed on 21/10/2094, but the dispute was referred in the year 2001. So according to them, it was delayed. So they approached before this honorable court. In that court, our case was that they immediately after dismissal, we raised an industrial dispute. It is the appropriate government who delayed the matter, and thereafter the matter was disposed of by this honorable court on 26/8/2009 by WPC number 5356.
Any order? Yeah. Any copy of the order?
No, but that order up to sir.
And what was the issue? How it was remanded back or what? Okay.
Dispose of this case.
Okay.
I can give the number. I'm trying to bring it out. 5356 of 2003.
I have a copy of the judgment.
Now, what is the decision? Why it was negated in your
the preliminary issue was
summary, brief, bird's eye view.
The preliminary issue was framed after remand of the preliminary issue was framed whether the inquiry conducted by the management is fair or not. The actually present inquiry officer was not examined. Presenting officer was not examined. Even no witnesses were adduced before the inquiry officer, they were examined. Only some officials of the garden, they have only simply produced the inquiry proceedings. Or they have who have no personal knowledge about the conduct of this inquiry. The learned presiding officer on perusal of those records, the witnesses of the management, witnesses of the workmen, cross-examination, etc., was of the view that the inquiry was fair. And he was of the opinion that as the allegation is serious in nature, he will not invoke the power conferred under section 11A. And accordingly, Miller, it has been held that the dismissal was justified.
Where is the judgment? Page?
Award.
Award?
Page 15.
50?
159.
15.
So let me read out this judgment. Award.
No, don't read that. Just give us the important parts. We are a certiorari jurisdiction. Relevant portion, findings.
Yes. Relevant portion, page 20 and 21. Let me read first 21 page. Let us first see whether the domestic inquiry held by the management in respect of the charge level against the workmen are valid or not. From the evidence on record, it is seen that the inquiry officer who conducted the domestic inquiry in this case has not been examined. At the bottom portion, page 21. Has not been examined by the management. MW1, Subhas Pallam, presently working as deputy manager of Bhutiachan Tea Estate, in his evidence claimed that the management appointed Sri N.K. Borua as the inquiry officer, and though he tried to trace him out, he failed to find out his whereabouts. He said, claim not disputed during the cross-examination. Let us now examine the other evidence on record and find out the answer to our question. In his evidence, MW1 admits that he joined in the Bhutiachan Tea Estate only on 2006. He claims that he deposed in this case on the basis of the facts gathered from the records maintained in the tea estate. During his evidence, MW1 proves Exhibit 1 as a written complaint dated 28/5/1994, filed a few workers before the management. Management, I have just brought some record. 25/5/94, filed by the few workers before the management against the workman Sri Moneshwar Gaur and against the workman Sri Bisha Keria regarding the alleged incident taking place on that day. He also proved Exhibit 2 and 3 dated 23/6/1994 as two charge sheets regarding the alleged incident.
What are the exhibits by the management?
Management's exhibit is, Your Lordship, Exhibit 2.
What is that?
The charge sheet.
Any notice to this person?
Yes.
Exhibited?
Yeah, that was exhibited. I am given to Your Lordship.
Huh? These are the exhibits.
Exhibit 2, it has come to the notice of management that you are also alleged to have committed the following offense. That is, it is served on Moneshwar Gaur. On 6 June 1994, around 12:45 p.m., you had gathered, gherao, along with some others in front of the office of the manager, Bhutiachan Tea Estate, on the same pretext, but suddenly turned violent and started throwing stones towards the office. You also hit the front of the windscreen of the gypsy vehicles of the estate, which was parked in front of the office of the manager, and with a stone resulting.
Now, what we could understand is that the labor code says though the presiding officer was not there, he died. Somebody died. Who died? Presenting
officer died.
And the presiding
Inquiry
inquiry officer could not be traced out.
because it was held for
However, the
14 years.
documents were proved. This is the finding. Documents were proved. So fundamental issue is whether principles of natural justice were violated or not. This is one aspect of the matter. Now, they have exhibited those documents. You have cross-examined. Now, what are the how have you established that there is a violation of principles of natural justice? That will be one area. The second area would be the other part, exercises of discretion and whether this was a case for because see, we are exercising certiorari jurisdiction. We'll just certify the record, not beyond that. We cannot replace our views. I think if this matter will take some time, may not be possible today. Again, unlisted matters are there.
Yes, Your Lordship has correctly said. Your Lordship has a very limited jurisdictions. Basically, Your Lordship is in certiorari. Whether there is an error apparent on the face of the record, and whether the learned tribunal or the labor code has failed to exercise its jurisdiction under Section 11. I am really, to be very frank with Your Lordship, I am try to impress your lordship about the invocation of section 11A
11.
because
Okay, that is what.
that is, but the occurrence took place in the year 1994. And now we are in the 2024. Even the matter is remanded back. That will not
No,
serve.
nothing.
So I have to take one chance only. Whether
Only on section 11.
Whether only on the section
Section
11.
11. See, otherwise, some kind of formality will, until and unless it is perverse, the findings on the material on the basis of evidence will not go into that. But so far relating to exercise of 11, we can very well enter into that arena.
When if your lordship goes to that action, it will not help me, Lord, because the accounts took place in the year 1994. So I will
Whether
try.
these clients are still in touch with you?
One client contacted me. Is Moneshwar Ghosh. So for the other client, Lord, I cannot.
Whether alive?
Bless it. But Moneshwar Ghosh.
94, yes. Long time.
94, that too.
And this.
Okay, we'll fix it when. Tell us.
Your lordship, please.
Initially, I thought I can dictate this judgment in the open court, but today might not be possible. Give a date.
Yeah,
because it's an old pending method that also disturbs us.
Immediately after the
Original
vacation clause.
reference its dispute started in 94. Original reference 2001. It's very bad on us. Whether we allow dismiss, that is a different issue.
13, the award was passed.
Everything should come to an end.
It will come to an end. That's
whether it goes in my favor or his favor.
Immediately after the vacations, any date?
Any date. Subject to lordship.
we are giving okay, give a date, Musim. October. Yes. 29th of October. As agreed to by the Learned Council for the parties, list this matter on 29th. That is the summary. Yes.
If required, I will.
May I just take the High Court order? I have one copy. I'll Xerox it and
Yes,
give
yes,
it.
you get it.
Yes, I'll just take a Xerox and give it to her.
Give it to him.
পিছত দিলেও হ'ব, 2-3 দিন দিলেও হ'ব। এটা মোক এটা কপি দি দিবা।
আপোনাক দি দিম হ'ব।
Okay. Likha. As agreed to by the Learned Council for the parties, list this matter on 29th of October 2020.
Obliged.
Issue now you understand, let us see.
That's all.
Yes, but who are the other side? Yes, Mr. Bora.
What has happened was that the petitioner applied for a water connection. And according to the petitioner, that water connection, the installation of the meter was left incomplete. The husband of the petitioner lodged a complaint. Now,
what happened to the meter?
It was installation was not done. It was left there at the premises, but it was not connected to the water main, the pipe. So husband of the petitioner lodged a telephonic complaint because that last mile connectivity that is done by some contractor, not by the board itself. Then suddenly, your lordship, they received this notice at impute notice at page number 25. Firstly, lordship, it appears that it was issued to some other person. Then they have struck off the name of that other person and written the name of the petitioner. Even the consumer number, there is some overwriting. Then we have gone to the office saying that kindly restore the water connection so that we...
Restore means not restore.
No, now they have installed the water meter. The meter is now installed.
Okay.
But there is no water. So what is to be done? Verbally, they have informed us that we have to pay reconnection charge of 20,000. Whether that is a penalty, some assessment, under what head that is.
Is this project started?
Yes, my lord. Last number 3, my lord, it has started. We are getting it, my lord. Some area there is no, but they are getting it. Now the tender has come, my lord, in that challenge, my lord. From that I have to know that 30,000 connection was given. There are 6 tenderers, they will get 5,000 each, and they are fixing it.
Okay. Now, what is to be done in this case?
I will have to get the instruction because that in paragraph in page number 24, the notice, disconnection notice, they said there is some dismantling of meter.
Yes, they have, that is what they have said. Page number 24.
Page number 24, type copy. Since the meter has been connected, there was some
So you do one thing, they have a demand.
No, there is no demand.
Huh?
Their demand is verbal.
And one
the
person
notice does not say.
So have you attended the office?
We have attended the office, submitted multiple, when we attended, they verbally said pay 20,000. So we are willing to pay that amount, but under what head, how that amount is to be paid?
Yes, Mr. Bora, obtain the instruction tomorrow. Tomorrow. List this matter tomorrow to enable Mr. S. Bora, Learned Counsel for SDD. Huh?
No, my lord, for the response number 2 and 3. 2, 3, 4.
2 and 3. To obtain instruction.
Deeply.
Then we'll see.
No.
Maybe just I'm tentative view. I do not know after what. Maybe that give the water supply, whatever is required, he will deposit subject to outcome of this writ petition. That will be the order. Both sides interest will be set.
What is the actual
Actual fact. Suppose you connect it, whatever is required, let him pay, subject to outcome of this writ petition. That will balance both parties' interest. Yes, 34 and 35. Yes, here for whom?
Please, Your Honor. Item number 61, Your Honor. We are unable to appear at that time, Your Honor.
You did not appear. Item number 61. What happened? I have signed almost all the orders.
Your Honor, मेरा matter will be listed tomorrow.
Service is not complete.
मेरा matter will be listed tomorrow, Your Honor.
No, that cannot be. What is the urgency?
The awarding of the contract.
Huh? Awarding of contract, we understand, but state service is not complete. Okay.
Police.
Now, what happened about that case? Pathak, tomorrow we'll close that. Huh? Yes. Where is Gogoi? What is to be done? He said some urgency is there, made him mention. Yes, come forward. Your matter is tomorrow, is not it? So tomorrow we'll complete it, or any difficulty?
No, actually, we have already completed.
Completed. All you have also given a note, written note.
Yes.
I just give a 2-line, I've just prepared a 2-line.
Reply to that.
Yes.
Also, we'll make it CAB and after vacation, or maybe
Because I forgot. 1 month back, I have prepared it. Again, I'll have to go back.
No, not necessary. He'll just give a written note of reply.
Yes.
We have fixed it to make it CAB tomorrow.
Yes, sir.
We'll make it CAB. Just
Very
be there.
Yes.
My lord, in this matter, today we are filing an affidavit, my lord, with regards to item 33 and 34.
You were supposed to file. So we have fixed this matter. Thrice it was called. Nobody was there. The petitioner also took time.
Shall serve a copy by the course of the day, my lord.
Then when we are fixing it on the reopening.
Reopening, my lord.
Huh?
Immediately reopening.
When? So we have fixed it on 21st.
My lord.
Okay, that's order will be there. We'll say that affidavit is being filed today.
Today.
That is just record it. And if it is not uploaded by now, because I keep signing all this during the lunch break. So I think everything is done now by now. Huh? Uploaded. Okay.
If tomorrow he raises any serious issue, then lordship.
No.
I already.
No, definitely. We'll give a fair hearing to everybody. No issue.